This is our first real meeting. We meet in December only to introduce each other. Today is our first real workshop. I would like to stress from the beginning that this each workshop is very important for our project because it is one of the fundamental instruments of our research in order to share our opinion and the results of this project have to be the fruit of our common work, of the collaboration of each partner. Today we have organized also our workshop with some speech, but each speech have to be only the instrument to give impulse to the debate. What is very important is the debate, is our sharing of our opinion about the different topics of our project. Okay, today we have to speak about the subject of the regulation, and in particular the meaning of the concept of a proceeding criminal matter and about the safeguards. We will have after my introduction. We have also today Professor Sigurella is another member of the team of Catania. The other time she wasn't with us. Today I would like to introduce her to the team, to the group. Okay, Rosaria, welcome. Okay, today we will have also a speech of Paolo Albuquerque. He is also a member of our advisory board, and he was a judge in the European Court of Human Rights, so he will speak about the concept of proceeding criminal matter in the opinion of the court, the European Court. We will have also a speech of Antonio Balsamo, who is a judge, Italian judge, and in particular he was also in the United Nations in the Italian delegation. Is an expert in preventive confiscation in the Italian system, but also in the European system of law about this topic. And so he will speak about also the safeguards in the regulation. And Spiezia, who is the head of the Italian delegation in Eurojust, who will speak about the first application of the regulation. But this speech has to be only an input. What will be important today is the debate. So to start, I would like to introduce the subject of today with a brief presentation with some slides, and after we can start our debate. I would like to share. Okay. Can you see the presentation?
Yes, we can see it.
Okay, perfect. Thank you. Okay. We also the other times we have stressed that mutual recognition has to be built on the harmonization from one side and on the mutual trust, which demands the respect for the safeguards of the rule of law on the other sides. In the next meeting in April in Catania, we will analyze the problem connected to harmonization with the report of each partner about the national models and about the implementation of the directive and also the new proposal of a directive. Today, we focus on the regulation and the respect for the safeguards. Okay. This regulation replaced the provision of framework decision 577 of 2003 and also the framework decision 783 of 2006. Maybe I said something the last time, but I would like to stress this aspect, the importance of the political strong value of the adoption of this regulation, which represents a doubly significant event. First of all, because the principle of mutual recognition is affirmed in this delicate sector in the wake of the framework decision 783, and also because mutual recognition is imposed with a directly applicable legislative measure, such as regulation, adopted with the ordinary legislative procedure on the basis of Article 82, Paragraph 1 of the Treaty on the Functioning of the European Union. In the first direction, I would like to stress that in the recital 13, it is strongly affirmed that while such orders might not exist in the legal system of a member state, the member states concerned should be able to recognize and execute such an order issued by another member state. So the European legislator has chosen the path of mutual recognition regardless of harmonization. We can remember that after the introduction of the directive, the Parliament and the Council invited the Commission to make a further effort of analysis or in order to present a legislative proposal on mutual recognition, or in order to analyze the possibility to introduce further common rules on the confiscation of property, and in particular on confiscation without conviction. The Commission, and in the end the European legislator, has chosen the path of mutual recognition with this regulation. In the second direction, instead, as stated in the Article 41, it is established that this regulation shall be binding in its entirety and directly applicable in the member states. Also in the recital 11, it is stressed this aspect. This choice of a regulation on the basis of Article 288 of the treaty and Article 82, it is real appreciable in terms of effectiveness because it is directly applicable in the member states, but it is also a bit problematic because this approach ends up attributing direct competence in criminal procedure matters to the European legislator, even if only for the purpose of vertical cooperation, in the absence of a more clear legislative will of the member states. So it is a choice that assumes a strong political value. This is also a reason which, on the basis of which it is very important, in my opinion, our research for the importance of this regulation. And so the importance of our work of research to try to give the best possible interpretation and implementation of the regulation. Even if this regulation involves only the cooperation and not the harmonization, and it is apparently unrelated to substantive issue, however, in this regulation, in this case, the mutual recognition ends to exercise a drag effect on substantive issue. The European legislator is so aware of this strong political value of that he had also chosen to stress in the recital 53 that the legal form of this act should not constitute a precedent for future legal acts of the Union. The choice of the legal form for future legal acts of the Union should be carefully assessed on a case-by-case basis. Okay, the scope of this regulation, all crimes, should cover all crimes. Otherwise, it is especially stated in recital number 14, not only the criminal offenses covered by directive, but also freezing order and confiscation orders related to other criminal offenses. It is not to be limited to particularly serious crime that have a cross-border dimension, because Article 82 of the treaty doesn't require such a limitation for measure laying down rules and the procedure for ensuring the mutual recognition of a judgment in criminal matters. We can remember also that in directive, which is based on Article 82 as well on Article 83, the Article 3 extends the definition of crime, not only the so-called Eurocrimes, but also other crimes which will be object of harmonization in the future. Okay, Article 3 of the regulation contains the list of serious crime punished with a prison sentence of at least 3 years, for which verification of the double criminality of the facts is not required, borrowing a choice for the first time adopted by the framework decision on the European arrest warrant. For the offenses not included in the list, recognition can be refused if the predicate crime is not a criminal offense in the states that has to execute the measure, based on the principle of double criminality. Okay, we will speak also about this aspect in the workshop about the practical issue. In the mutual recognition of a seizure is also established in the regulation. For the seizure order or freezing order, which are issued by a non-judicial authority, an authority designated by the issuing states, which is competent in criminal matters to issue or execute the freezing order in accordance with the national law, and which is not a judge, court, or public prosecutor. This is possible, but in any case, the regulation claims that in such case, the freezing order should be validated by a judge, a court, or a public prosecutor before it is transmitted to the executing authority. It is not required. It is, my opinion, this could be better, that any freezing order or seizure order pronounced by the public prosecutor is validated by the judge. Okay. First of all, Article 2, number 8b demands for confiscation authority which is competent in criminal matter. It is established the issuing authority means an authority which is designated as such by the issuing states and which is competent in criminal matters to execute a confiscation order. It is specified that the provision must be a confiscation order issued by a court in accordance with national law. What means a court competent in criminal matter? It is interesting a judgment of the European Court of Justice, Grand Chamber, in the case Balaz of 2013. In this case, the court stressed that the term court having jurisdiction, in particular in criminal matters, in this case was is about the application of the framework decision on the application of the principle of mutual recognition to financial penalties. In this case, the court stressed this term, court having jurisdiction, in particular in criminal matters, must be interpreted as an autonomous concept of union law, and if so, what the relevant criteria are in that regard. So this is very important, in my opinion. The court affirmed that the meaning of a court having a jurisdiction, in particular in criminal matters, can't be left to the discretion of each member state. The classification of offense by the member states is not conclusive. The national judge is formally established in this case as an independent administrative authority. A jurisdiction as an appeal body in relation to administrative offences, but this appeal body has a limited jurisdiction and applies a criminal procedure which is subject to compliance with the procedural safeguards appropriate to criminal matters. To the end, the court having jurisdiction with the meaning of Article 1 of the framework decision must apply a procedure which satisfies the essential characteristic of a criminal procedure, without however it being necessary for that court to have a jurisdiction in criminal matters alone. In this case, this authority has unlimited jurisdiction and applies a criminal procedure which is subject to compliance with the procedural safeguards appropriate to criminal matters. So this can be also an important judgment for our interpretation of the meaning of the authority competent in criminal matters. So in the end, in this case, the European Court of Justice affirmed the importance of the procedural safeguards and in particular the principle nulla pena sine legge, and the principle that the culpability should arise only where there is capacity or criminal responsibility, the principle that the penalty must be in proportion to the degree of responsibility and so on. Okay. Other important element, Article 2 of the regulation, the definition of a confiscation. Confiscation means a final deprivation of a property ordered by a court in relation to a criminal offense. So we have another time in relation to a criminal offense. So all types of confiscation order are considered in order to impose the mutual recognition. First of all, the kinds of confiscation orders covered by the Directive 42 of 2014, direct confiscation, confiscation of the value, extended confiscation, confiscation of assets in the possession of third parties. Non-conviction-based confiscation is also considered, and first of all, in the case of absconding and illness, which is considered by Article 4 of the Directive, but also other types of orders issued without a final conviction. Not only orders covered by the Directive. The term therefore covers all types of freezing orders and confiscation orders issued following proceeding in relation to criminal offense, not only covered by Directive, orders covered by Directive. Also other types of orders issued without a final conviction. In the explanatory memorandum, it is of the proposal, of the first proposal of the regulation, was stressed this aspect. Non-conviction-based confiscation, also in the case of death of a person, immunity, prescription, when the order is statute barred. Also cases where the perpetrator of an offense cannot be identified, or other cases where a criminal court can confiscate an asset without conviction when the court has decided that such asset is the proceeds of a crime. This is affirmed in the explanatory memorandum of the proposal, regulation proposal. Provided that the confiscation is, on the basis of Article 2, a final deprivation of a property ordered by a court in relation to a criminal offense, regulation doesn't demand as the directive that a criminal trial has begun, but the sentence cannot be pronounced, but precisely as an hypothesis of a real action in rem, of an autonomous proceeding against assets related to a crime. Also in Article 8, where we can find an exhaustive list of grounds for non-recognition and non-execution of confiscation order. This list differs significantly from the list contained in the Framework Decision 783 of 2006, even if some grounds remain, for example, the respect of the principle of nebis in idem. However, the grounds for refusal linked to the type of the confiscation order have not been included in the proposal. In this way, the European legislator has considerably broader and the mutual recognition framework. And other very important rule in the Article 1, we can read that this regulation lays down the rules under which a member state recognizes and executes in its territory freezing order and confiscation order issued by another member state within the framework of proceeding in criminal matter. So, proceeding in criminal matter. Today we will try to understand and to interpret what means proceeding in criminal matters, as opposed to within the framework of criminal proceeding. In the first proposal of 2016, in the original version, in order to be included in the scope of the regulation, the confiscation orders had to be issued within the framework of a criminal proceeding, with all the safeguards applicable. After the proposal of 2006, in particular, the Italian, the Irish delegation worked to change this expression, criminal proceeding, in a proceeding criminal matter. We can find also this debate in this document of the Council of the European Union in this of 2017, which is explained that in the proposal presented by the Commission was used this expression criminal proceeding, but there are different systems of confiscation in place in the member states, including various forms of non-conviction based confiscation. And Italian delegation in the working party has stressed that the words criminal proceeding posed a problem because it was not possible to include confiscation systems that, while being clearly linked to criminal activities, are not conducted in the course of a criminal proceeding. The Italian delegation, supported by some other delegation, observed that the proposed wording criminal proceeding posed a problem since its system of so-called preventive confiscation would be excluded. Italy explained that under this system, we can read this in this document. Italy explained that under this system, a confiscation order are issued by a criminal court in proceedings that are not aimed at convicting the person for committing a specific offense, but are based on proven facts that assets are derived from criminal activities. while also taking into account previous criminal behavior of the person. This system, preventive system, is called preventive system in the sense that confiscation order issued under this system aim at preventing the use of property which is proved to have derived from criminal activities committed in the past. According to Italy, this system would not fall, at least not entirely, with the notion of criminal proceeding. However, Italy suggests using the concept of Article 82, paragraph 1 of the treaty, and referring to proceedings in criminal matters, in order to include system of preventive confiscation. Italy confirmed that the fundamental rights, similar procedural safeguard as in criminal proceeding, are adequately respected, that the confiscation order under this system of preventive confiscation have a clear link with the criminal activities and therefore fall in principle within the framework of proceeding criminal matter. The Italian delegation also quoted the notion of criminal matter adopted in the directive on the European Protection Order for Victims to allow the recognition of orders for the protection of crime victims taken by a judicial authority that is not only criminal but also civil or administrative. During this meeting of the working part, a number of member states indicated that they could support or at least accept the modification requested by Italy, stressing that the importance of to extend the system that could benefit from the application of the regulation and the importance of the Italian system, which is considered to be one of the most effective confiscation systems. Other member states expressed their doubts. They observed the Italian system of preventive confiscation seems to be of a hybrid nature, criminal and administrative. They wondered whether this system would be covered by the legal basis of Article 82 of the treaty, and also inquired whether in the Italian system there is a link between the confiscation order and the criminal offense, or whether the procedural rights of the person concerned would be adequately respected. In the end, the European legislator has chosen to change this expression, so now we can read within the framework of proceeding criminal matter. Proceeding criminal matter is an autonomous concept of union law interpreted by the Court of Justice of the European Union, notwithstanding the case law of the European Court of Human Rights. This is very important. This reference to the Court of Justice seems appropriate because the adoption of a regulation in a more direct way call into question the Court of Justice as interpreter in its original capacity, intended to resolve the interpretative doubts of member states. In the recital 13, it is also affirmed that the term therefore covers all types of freezing order and confiscation order issued following proceeding in relation to a criminal offense. Article 2, we analyzed it before, in the definition of confiscation, affirm a final deprivation of a property ordered by court in relation to the criminal offense. So we find this expression, in relation, proceeding in relation to the criminal offense. In the interpretation of this expression, also in the context of a debate of the European Union Minister of Justice, has affirmed that also preventive confiscation are included in the regulation scope. So, with this modification, proceeding criminal matter, as emerges also in the recital 13, and in the press release of 8 December 2017 on the orientation reached by the Council on the proposed regulation, we can affirm that on the basis of the regulation, mutual recognition covers a broad spectrum of confiscation, include those adopted without conviction, and including certain preventive confiscation system, provided that there is a link to a crime. So, proceeding related to the profits or instrument of offense, where there is in a clear way a link to a crime. Also, in the opinion of the European Court of Human Rights, in some judgment, the court, in examining the form of extended confiscation, also in the light of Article 5 of the Directive, Article 5 of the Directive is the article about the extended confiscation, and the recital number 21, that is the recital about the standard of the proof for the application of confiscation. In the recital number 21 is affirmed a kind of reinforced the civil standard, substantially more probable that the assets have illicit nature. In this case, the European Court recognized the correctness of the procedure for ascertaining the illicit origin of goods. What is important in the opinion of the court is to verify, to ascertain a link between proceedings and criminal activity, understood in a broad sense and demonstrable even with presumption, in the absence of which the confiscation represents a disproportionate sacrifice of the right of ownership pursuant to Article 1 of the first protocol of the European Convention. So, what is important is the ascertainment of this link, of this connection between proceedings and criminal activity. In the recital 13, it is also affirmed that the proceeding in criminal matters may also include criminal investigation by the police and other law enforcement authorities. This rule, it's not a rule, it's only a recital, but in my opinion, this is not acceptable. That the regulation in a system where there is the principle, the rule of law, in a rule of law, that the regulation can refer to form of freezing and confiscation order not adopted in a judicial proceeding, but in the investigation phase, it is not acceptable because the freezing order, sales or the confiscation are always form of a limitation of a citizen's right, the right of property, which is guaranteed by Article 1 of the European Convention and Article 70 on the Charter of Fundamental Rights of the European Union. And also in the definition of confiscation of the Article 2, number 2 of the regulation, refers to a measure taken by a judicial authority. Also for the freezing order, on the basis of Article 2, number 8, at least must be validated by a court or a public prosecutor in the issuing state. So, in my opinion, it is not possible to interpret the proceeding to include in the concept of proceeding criminal matter also criminal investigation. No civil and administrative proceeding. This is established in the Article 1, number 4 of the regulation, and it is stressed in the recital 13. This regulation doesn't apply to freezing order and confiscation order issued within the framework of proceeding in civil or administrative matters. But the problem. The concept of a proceeding criminal matter in this sector is not always clear. Okay, in the autonomous concept of union is a broad concept, is a proceeding connected with criminal, with the proceedings of instrument of a crime, with a link to criminal activity. But there are many kinds of proceeding which are possible to define hybrids. because they are held before the criminal court, but without the safeguard of the criminal matter. There are many also in the Italian preventive confiscation, but I think also and so the Spanish decomiso sin condanna or many other form of civil recovery, civil forfeiture. Which are forms of confiscation without conviction, included in civil or administrative matters, but which fall perfectly in the definition of proceeding in relation to criminal offense, because they are related to the proceeds or instrument of offense. The model which has inspired the regulation was the German confiscation without conviction. In the proposal, in the explanatory report of the proposal, the European legislator analyzed the German model of confiscation without conviction. In the sector of the fight against organized crime and terrorism, adopted in the reform of confiscation in 2017, in the German system of law, on the basis of the paragraph 76, paragraph 4, we have this form of a kind of action in rem. If based on all circumstances of the case, the court is convinced that an object is the proceeds of crime, even if the person affected by the confiscation cannot be prosecuted or convicted for this crime. Also in the Strasbourg Convention, we have this notion of proceeding criminal matter as connected with a crime. In the explanatory report of the Strasbourg Convention of 1990, Strasbourg Convention is very important because before the introduction of the regulation, it was one of the fundamental instruments for the cooperation in this sector. In this instrument, the interpretation, the explanatory report of proceeding in criminal matters is very broad. Any proceeding carried out by the judicial authority and with criminal nature in the sense of covering instruments of proceeds of crime. So it's only a link with the crime. But the regulation demands the safeguard of a criminal matter in the member states. Demands that the confiscation is applied not only in proceeding criminal matter, but with the safeguard of a criminal matter. We can find, okay, we will have a specific speech about this topic of the safeguard. I would like only to remember that this regulation, also in the Article 1, this regulation should not have the effect of modifying the obligation to respect the fundamental rights and legal principle enshrined in Article 6. In recital number 17 is also stressed the regulation has to respect the fundamental rights provided in the European Convention, European Charter of Fundamental Rights. In the recital 18, also it is stressed the importance of the procedural rights set out in the different directives, and above all, it is affirmed, in any case, the safeguard under the Charter should apply to all proceedings covered by this regulation. In particular, the essential safeguards for criminal proceedings set out in the Charter should apply to proceeding criminal matters that are not criminal proceedings, but which are covered by this regulation. Also in the directive, Article 8 of the directive, stress the importance of the safeguards, in particular, the right to an effective remedy, a fair trial, adversarial judicial proceeding. In the recital number 15, it is pointed out that the cooperation among member states have to respect the principle of legality, subsidiarity, proportionality, and the rights of third parties in good faith. Among the ground for refusal, also, it is established that one of the possible ground for refusal is the case of a violation of the safeguard, a manifest breach of a relevant fundamental right, as set out in the Charter, in particular the right to an effective remedy, fair trial, and the right of defense. Also the principle of bis in idem. So the hybrid confiscation proceeding on the member states have to respect the safeguard of the criminal matter in order to apply the regulation. And so it is important to verify if the confiscation is adopted in a proceeding criminal matter with the connected safeguard. The regulation so could represent a challenge to provide for a complete jurisdictionalization within the criminal law of a proceeding seeking to enforce form of a non-conviction-based confiscation, or in any case, form of exempt confiscation that normally are applied after conviction, but in some cases are applied without conviction. Also, for example, in the Italian system of law, our extent confiscation, which is normally applied after conviction, in some cases, when, for example, after prescription, when the crime is statute barred, is possible to apply also this form of confiscation. So the problem is, the challenge for the future is that this form of hybrid proceeding, in order to be included, to be covered by the regulation, have to respect the safeguard of proceeding criminal matter. So the regulation can be an incentive to adopt a model of a trial against property compliant with the criminal law guarantee. Okay, I suppose that I have spoken too much. I prefer to stop myself in order to start. Okay, to start our debate after this presentation. I would like to that each partner or each member of the advisory board which is present, or each expert that we have today in our workshop, express his opinion about the interpretation of proceeding, first of all, of a proceeding in criminal matter, which is the interpretation, which is also the first practice in the application of the regulation. And also after we have also to analyze which are the safeguards to apply in order to include a proceeding in criminal matter in the scope of the regulation. I suppose that we can start with a free round of contribution. Somebody would like to start?
Anna Maria Ernesto.
Sì.
Thanks a lot, Anna Maria, for this clear introduction to the regulation. I have a couple of questions to you. First, as Italian, I would like to know if there is a conclusion of the discussion about implementing the Italian legislation or not. It looks the Court of Justice will make a decision enlarging or allowing. The second question is, for sure, it's a complex regulation with a lot of exceptions between countries. My doubt is the following. With this machinery, how is the implementation of the regulation? We have 4 years of implementation, or at least 3 years. do we have any data on countries demanding and countries accepting? Or probably it would be very useful, probably this afternoon from Spezia, but I will not be here, to know who is working better than others, which means it will be extremely useful for us in the project to know what are the compatibilities between different countries and different legal systems. And this will be given by the number of the requests and the number of implementation of the regulation.
Okay. Okay, it is clear that in the interpretation of the regulation is included also Italian preventive confiscation, because it is the change also of the regulation was adopted in order to include explicitly the Italian preventive system. Also in the debate among the Ministry of Justice was stressed that some form of non-conviction based confiscation have to be included as preventive Italian preventive confiscation. So the political direction was clear, and also it is also clear because we will speak also about this in the next meeting, but in any case I can say from now that it is clear that Italian confiscation preventive measure is applied in relation to an offense as affirmed in the recital 13, because it demands that the recipient is considered a social danger because he or she is suspect of a criminal activity, because it's a confiscation of assets of criminal origin. The value of the assets is disproportionate to declared income or economic activity, or when it transpires that they are derived from illicit activity or used for investment, and are assets for which the dangerous owner has not demonstrated legitimate origin. And also in the law of 2015, in order to implement the previous framework decision 783, was expressly affirmed by the Italian legislator that the proceeding in order to apply the confiscation preventive measure is a proceeding, a criminal proceeding. In that law of 2015, the Italian legislator has affirmed that the proceeding in order to apply preventive measure is a criminal proceeding. So there are no doubt about the possibility to apply this regulation to the Italian preventive confiscation. In the praxis, I will, Filippo Spezia has told me something about many problems in the praxis, because in his opinion, about only 45% of the cases, the other member states accept really to apply the Italian preventive measure. But I prefer to leave to Spezia the speech to speak about this first praxis. He will be here in the afternoon. It is also strange, in my opinion, because in many member states we can find now form of confiscation without conviction. Also in Germany, no, which has been always considered a legal system very respectful of the safeguards of the rule of law and so on. So we will analyze this aspect also in the about the practice with Spezia. I would like to say another thing, but I don't remember. Okay, now I would like also we will speak also in the future about the application of the Italian system or in the practice. But now I would like also to understand which is the opinion of the other partners, about this interpretation of the regulation. Maybe if you prefer, I can give the floor in order to our partner. Okay, maybe we can start with Spain. Francisco.
Yeah, hello, good morning.
Good morning.
Thank you for your in the first place, thank you for organizing this seminar, and thank you also for your speech, because we really it really set up the scheme, and the scheme is not an easy one. It's a very confusing scenario, I must confess. In Spain, in particular, we managed to set up from the substantive law a very clear regulation, introducing all the novelties stemming from the 2014 directive, and now our criminal code is in line with non-conviction-based confiscation and also extended confiscation. And even in relation to extended confiscation, we have different types and modalities. And I think they are, a brand new legislation for us, and a very important aspect to clarify in relation to our criminal law. But at the level of the procedural level, we are now facing a new bill in order to adapt the regulation to our what we call, we try to compile all the mutual regulation instruments, mutual recognition, instruments in a single law. And now we are trying to adapt our mutual regulation law to the 2018 regulation on freezing and confiscation. For us, the key question is, okay, we understand that we have to, and the regulation also is in favor of having a flexible approach in relation to these hybrid models and hybrid proceedings. But what happens with Article 1, paragraph 3? What happens with these freezing and confiscation orders that are issued within the framework of civil and administrative proceedings, or proceedings in civil and administrative matters? Because there is a clear section, and also the point number 13 of the preamble underlines that these type of civil or administrative matters proceedings are not included in the scope, or are not under the scope of the regulation. And for us, it's very difficult to distinguish which certificate has been issued in this sort of proceedings, and which are under the type of proceedings that are proceedings issued in the framework of criminal matters proceedings, because previously in the previous years we have a clear distinction in relation to these proceedings is coming from United Kingdom, and we decided not to execute and not to recognize the freezing orders coming from, for example, the Queen's Bench Division Court. But now, in relation to many of the member states, like Italy, but not in particular Italy, but Slovakia, Bulgaria, even the Netherlands, we don't know if we are dealing with a pure civil or administrative freezing order, or stemming from a civil or administrative proceedings, or on the contrary, we are dealing with a freezing order issuing a confiscation, separate confiscation procedure, a non-conviction based confiscation procedures, but clearly linked with criminal offenses and issued, and that is very important also, by a judicial authority. Also in a flexible approach, considering also the possibility of validation. That is a very interesting possibility, also provided in the 2018 regulation. And that is the scenario we are facing, and we are obliged to give clear guidance to our prosecutors and to our judges. And we don't know exactly how to do this, how to draft a guide or a manual in order to provide a clear guidance to our colleagues. And I think this is one of the main and most interesting aspects of this project, to find a way to clarify this scenario, the case scenario we are facing now. That is not really clear. Also, in the ongoing process that we are facing to adapt our mutual recognition law, because this is not a national problem for us. We have a very clear legal system, but at the same time, we are bounded by the mutual recognition obligations. And it's not a national issue, but a transnational issue, whether we have to recognize and execute certificates coming from our neighboring countries, our our member states within the European Union, and because we are obliged on the basis of mutual recognition to recognize this sort of certificates. If we deal with rogatory letters coming from other countries, from the Council of Europe conventions, and I'm thinking about 1990 convention and also 2005 Warsaw Convention. Perhaps we have to apply another approach, taking into account the declarations and the reservations that Spain already made in relation to these conventions and legal instruments. But within the European Union, the approach is completely different. That is why we need to clarify these concepts, and we need to clarify which are the resolutions that should be recognized and executed in Spain. And in these regards, I think that our project is really a very nice and timely project to do so. Thank you so much.
Thank you, Francisco. After I would like to say something about now, I would carry on the other contribution. Professor Giovanni Grasso, who is a member of the team of the University of Catania, would like to give his contribution. Giovanni? Or is it only Balzato?
Okay. I am here. No, thank you. Thank you, Anna Maria. Congratulations for your presentation, which was very extended. You have dealt with a lot of questions, and I prefer to hear only and to intervene in another moment. Thank you.
Okay. Okay. Okay, so we can. Okay, there are other. Michele Fini. Okay, Fini. Good morning, Michele. Michele is.
Good morning, Anna Maria. Good morning, everyone.
Judge is our representative for the Italian Ministry of Justice, which is also a partner of our project. Thank you, Michele. You have the floor.
Yeah, good morning, Anna Maria. Good morning to everyone, and also special greetings to my colleague Francisco, who's there, and to all the other colleagues and professors who are here. Thank you for your presentation, very clear, and the best way to start out this workshop. I do agree with your final advice on the actual implementation of the regulation, which is meant to be covering the Italian no conviction-based confiscation. This is also my opinion, and this has been considered when considering all the issues connected. I mean, I'm talking about the grounds and the contents of the discussion which went on during the aforementioned working group open meeting while negotiating the regulation, the choice between the wording criminal proceedings and proceedings in criminal matters was done with a view to covering these special measures we have been dealing with for so long time. So we know that choice finally was made to cover these instruments, these tools within the scope of the regulation. But also the conclusion can be drawn while considering the wording which had been eventually adopted, which of course, according to the normal view of interpretation, covers this tool, because criminal matters are definitely involved when it comes to this kind of preventive measures adopted by the Italian system, and not only the Italian system, because we are still talking about someone who has been involved in crimes, even though it's not the crime which is being judged, but it's a crime previously committed, which is also the base in order to evaluate the other elements which are taken into account when applying these kind of measures. But I have to say also that this conclusion is justified also by the new trends in the European systems. These new trends, of course, normally include these kind of measures in many other countries, not just in Italy. I remember in 2018, I was involved in a meeting, ANCAC meeting in Wien, with our friend and colleague Antonio Basmo, who is going to talk to us later on. And it was about the ANCAC convention in Wien. And I delivered a speech based mainly on the article Antonio had just published on a legal journal. And finally, the instant report the Secretariat sent out was particularly careful in order to take account of what we have been saying, and so stress out the importance in the new system of no conviction-based tools for confiscation. So the new trends also justify this conclusion, which for me is that we are definitely allowed to consider the Italian preventive confiscation measures to be covered by this regulation. Thank you for your attention.
Professoressa, ha il microfono spento.
Sorry, I have the. Okay, I would like to thank you very much, Michele. I would like to carry on with the other partner to intervene. From Poland, we have somebody.
Good morning.
Good morning.
Good morning. I am a judge and a PhD also. I am representing Ministry of Justice. First of all, I wanted to thank the chair for the very interesting presentation, which was really a very nice introduction to our project and today's seminar. And then, you know, after having followed the presentation, we can see how wide, how broad is the problem, particularly from the comparative law point of view. Why I stress this? Because to my mind, if we follow just only the regulation for the first side, there is not that much. It is not that much problematic, but of course the problems are in the details. Because if you follow from our national point of view how to determine criminal matters, of course criminal matters from the point of view of the regulation in hand, we have to go down through the articles. Then from the first article, if we jump to the second one, we can see issuing authority, executing authority. We see who is issuing the decision. We see judge, public prosecutor, and some other organs. But then in Article 3, we have clearly determined the scope of application. Article paragraph 1 list of criminal offences, and at the beginning of it also it determines that the maximum sentence, custodial sentence provided by the law is at least 3 years. So in that way, we see that first of all, it has to be criminal offense. Even if it is a proceeding in rem, it has to have a link with these cases. Problematic maybe can be paragraph 2 of Article 3, which makes a reference to the other criminal offences that can be also, let's say, taken into account within cooperation based on this regulation. But you can see that I wonder, first of all, what is your opinion about it? Whether in the paragraph 2 we can have any criminal offense, or Also criminal offense not mentioned in the list of paragraph 1, but those who are maximum of at least three years of custodial sentences. I believe that this condition is not included to the paragraph 2, but however, it may cause the problem, especially in case of PT offenses. You know, comparing to, in English terminology, these are misdemeanors, and then whether we apply this in the criminal proceedings as such, in case of paragraph 2, can we take into account misdemeanors? For Polish system, we have a special proceedings which is not directly criminal. It is the proceedings in misdemeanor cases. I also would like to know whether it may constitute a problem in some other countries. For example, I am aware of Spanish and French system where, except of criminal offenses, en France, nous avons contravention. We have a contravention in French. In France, tenemos faltas. We have faltas in Spain. These are like minor offenses, but however, it may constitute a problem because in Poland, when we would execute this one, surely misdemeanor, falta, contravention, it is not criminal proceedings, neither criminal offense. So this is what I wanted to signalize. And of course, beyond that, we have all the types of those cases who are investigated and who are in rem case. There is no charge against a particular person. It may constitute a problem because, well, when the regulation was established, we are still in process. I believe all the countries of European Union are in the process of establishing special procedures to that, especially from the point of view of extended confiscation, which is are not related with a particular conviction. The same is with the responsibility of collective entities, which is also a kind of criminal proceedings, but differently determined in many countries. And if we don't need this predicate, which is a conviction of a natural person for the responsibility of a collective entity, then we face the same problem. So I believe there are many things to be determined. For the moment, I'm fully aware that knowing more about your national system, we can see immediately the problematic issue, because first of all we have to think and analyze this from the point of view of a judge who will be in future taking care about proper executing of a request of a EU country which is demanding to anything according to this regulation. So maybe I will stop in this moment and then to give the floor as a delegation. Thank you.
Thank you so much. I would like only to say two things. First of all, we speak. We will have also a specific workshop about legal person, the possibility to apply confiscation to legal person and all the issue connected. This is another a real big issue. the scope, the aim of our project is also try to better know the different system of law in order to understand if contravention is a criminal offense or not, is included or not. And I hope that in the end our next meeting is specifically about for each delegation, which are the form of confiscation which are included in the regulation. And it is interesting, the problem, in my opinion, because about what Francisco said before, no? Okay, in my opinion, the idea that I have, but I can change also, is that this concept of a proceeding criminal matter is a very broad concept. That means each proceeding which deal with something which is connected, in particular proceedings or instrument of a crime. And the court, as affirmed by the European Court of Justice, can be not a court which has also competence in this sector, but not only in criminal sector, also in other sector, administrative, civil. But what is important is that it is a judicial authority, and which the judicial authority deal with the something which is connected to a crime. Also, in the opinion of the European Court of Human Rights, we will analyze after, but in many cases, the European Union has affirmed that what is important in order to recognize this form of extended confiscation, non-conviction based confiscation, is to demonstrate this link with a crime. Because, for example, in a case against Romania, Dimitrovi case, the court said that it was not possible to admit a form of extended confiscation, non-conviction based in extended confiscation, which was justified only to the aim to protect the economy and not to fight against the crime. No? So what is important is this link with the crime. The real problem in the end is, in my opinion, to understand which are in this broad concept of a proceeding criminal matter, which are the safeguards that we have to apply. Because also in the past, the European legislator has always affirmed, okay, in the different also directive or framework decision, member states can have to apply at least this extended power, but they can apply more extended power. But it has not established which are the minimum safeguards to guarantee. This is, in my opinion, also the problem. Which are the necessary safeguards that a proceeding criminal matter has to respect in order to be included in the regulation. And the problem from, I don't remember the name of the member of the Poland Ministry of Justice. One problem is that in many of these proceedings in criminal matter, in order to confiscate the proceeds of crime, the prosecutor is able to confiscate without the proof of the derivation from specific crimes, but with a proof of a legal origin. So this can be a problem because in our regulation, it is established that criminal offense has to be or a criminal offense which is included in the list in order to avoid the double the application of the principle of double criminality, or if it is not included, it is possible the verification also if in non-formalistic way, no? In the recital 40, it is established that the verification of double criminality must be carried out in non-formalistic way. This means the competent authority should verify whether the factual elements underlying the offense in question would be liable to criminal prosecution in the territory of the executing states, regardless of the offense nomen iuris and the perfect correspondence of the constituent elements of the internal crime and the one configured by the issuing authority. But this means that at least in a proceeding criminal matter, in some way, it is not. In some way, it is necessary to give evidence of the origin from specific crime. This can be, in my opinion, a problem because in some cases, in the application, for example, of the Italian preventive confiscation, okay, the owner has to be suspected of some crimes, but it is possible to apply, to confiscate the assets also in case where the asset have a proportionate value in relation to the economic activity without specific evidence of the origin from specific crime. We have a kind of negative evidence. There is no evidence of a legal origin. The assets have a disproportionate value, and so there is the presumption of illegal origin. So this can be, in my opinion, it is a problem because in any case, it is necessary a connection, a link with a specific crime in order to establish that if the crime is included in the list of 32 crimes or no. Okay. Sorry for my interview. I would like to give the word to Vanya Ilieva. Please.
Hello.
Hello.
Hello. Do you hear me? I suppose you do. Hello, everybody. Let me introduce myself because I wasn't apart from your December meeting. My name is Vanya Ilieva. I'm a prosecutor in the General Prosecutor's Office of Cassation in Bulgaria. So thank you, Anna Maria, for your valuable presentation. It was very interesting because for me, because we got some practical issues in Bulgaria, and I was very glad to hear the broader scope of the issues that might come from the implementation of the regulation. Also in Bulgaria, or when member states execute our orders for freezing or confiscation. The topic of the proceedings in criminal matter is, of course, very important because every system has its specifics, and when we are talking strictly about criminal proceedings which are started by a prosecutor and they are related to a specific crime, maybe there are not a lot of issues connected with it, but of course in Bulgaria we have some different proceedings which are connected with crimes, but eventually they end with administrative punishment or they are some kind of mixed type of proceedings between criminal and administrative. From the other hand, in Bulgaria we have quite complex confiscation system. One system is connected with criminal proceedings, and it It is started by the prosecutor, and from other hand, we have a special authority which deals with so-called civil confiscation. But in any ways, this civil confiscation is also related to crimes, or if there is no other, as you said before, Anna Maria, no other legal origin for the proceeds in question. The good thing in the view of the regulation is that confiscation in Bulgaria is a punishment or a measure imposed by court. So this could not be some kind of a problem, but when we are talking about freezing, that might be some kind of problem, because freezing orders is a different procedure, and it might be connected with a special procedure which is which aims to deprive legal entities from proceeds when representatives of legal entities are convicted with committing a crime. So a lot of issues can be marked and discussed in relation to the topic. So we are welcoming any description of other legal systems, and of course we aim to contribute a lot in this matter. Thank you very much.
Thank you. Thank you. We started to know also the Bulgarian system of law. Francisco, would you like to intervene, or before you have the?
Yes, Anna Maria, only in relation to the remarks made by the Polish judge. I think his name is Wiltot Hakinko. Sorry if I pronounced not well, because it's interesting also to discuss what is the scope of what we consider offenses that are included in this mutual recognition system. He referred to the possibility of issuing a freezing order or a confiscation order in relation to misdemeanors. Of course, this is not an option in the Spanish legal system, and based on two main principles. First, principle of proportionality is not proportional. And the second one is the principle of legality, that is also very important in relation to the regulation, because lex loci criteria is in Article 23. And in accordance to this article, and if we go to the Spanish Criminal Code, in the Spanish Criminal Code, we have a provision, Article 127, that specifically provides that confiscation is for offenses, not for misdemeanors. It can be intentional or reckless, but in any case should be offenses, not misdemeanors. Then no faltas are allowed to be the legal basis for freezing or confiscation order. And that is important to highlight in relation to double criminality also, mainly because proportionality principle is one of the key principles of legal safeguards in relation to this particular field, to confiscations. Thank you, Anna Maria.
Thanks so much. This is very important, yes, for our research to stress this aspect. Okay, we have another hand. Witold, would you like to intervene?
Yeah, I just wanted to thank you for the explanation to Mr. Francisco Jimenez Villarejo. I wanted to say that exactly he stressed another element that will be following us not only through misdemeanors, but also with the through extended confiscation, through all these proceedings when we have a seizure or confiscation without a defendant or without a context, which is proportionality. This is like for me basic issue, to use a proper tool, not to kill an ant with a bazooka, but adjust these tools. And it will be, I wanted to stress it because making a reference to what the Madam Chair said at the commenting my few words, it was about, because we also face similar problems. We have those problems are mainly when, in fact, there is no proceedings in personam. We have a seizure or a blockade of accounts according of a bank account according to provisions preventing money laundering and terrorism, which is, in fact, which can, and we have to think about it, because this provision in part is constructed as such that for the period of 6 months, when there is only a possibility, according to the prosecutor, of committing a crime, he can make a blockade of the bank account of an enterprise. And what can happen then? After 6 months period, he can extend the period for another 6 months, where we have no, in fact, no charges, no investigation pending against a person, and the only possible verification is to appeal this decision to the court. So, and then nothing happened. And what can happen in the, let's say, commercial sphere? It may happen that this enterprise may just simply fall down after having its account blocked through the period of 1 year. So just as an example, we have also maybe in the questionnaire, I will include these judgments of the Supreme Court on that issue, but this is extremely important. We are focused on fighting criminal offenses, but we should avoid, let's say, killing those who are really randomly on the line of shooting. So thank you very much.
Thank you. We told now maybe we can carry on with Germany. We have Professor Egger.
Oops.
Is here?
Yes. Hello.
Yes. Okay. Hello, Martin.
Yeah. Hello. It's very interesting for me, but I think the situation in Germany, perhaps it's a little bit different, because we in our implementation law on the regulation, we only focus that that we should use the regulation, and then in the context of a criminal proceeding, we have to accept it. And there is no wording or no clear saying what is a criminal proceeding. It must be a confiscation or whatever order or freezing order in the context of a criminal procedure. And looking on the German procedure, perhaps it's interesting because it's the background. In our, if Germany is issuing a freezing order or a confiscation order, then it is part of the criminal procedure law. It is up to the criminal courts to decide on freezing as well as on confiscation. without a criminal case or not. It's only the non-conviction-based confiscation is a decision of a criminal court, as well as the freezing, etc. And on this background, I think it's not really a problem for German courts. They only look, is it the decision of a criminal court or in a criminal procedure within the framework of the other state? And then we can accept it, and we must accept it. This is the basis. And in my opinion, there is no big problem on this issue. It is very clear that I think Francisco has named the countries in which there is only freezing or confiscation on the basis of private law or civil law or administrative law. In these cases, I think it's not possible to accept this, but it's not necessary, and it's not acceptable basing on the regulation. And so I think it's a more formal approach on our background. Perhaps I misunderstood some of your aspects, but as I see, the German legislator did not see big problems. It focused on the regulation and said it must be the context of a criminal procedure. And as I said, I think it's with the background that we do it this way, despite of the aspect whether it is a criminal trial or not. We say it's up to the criminal courts to decide on all these measures. And I think this is the background for us, and so it must be a context to a criminal case, but it must not be a criminal proceeding in the sense that it is something like a criminal trial with the aim of a conviction. It's not necessary, because otherwise it is not possible to impose measures in between, before the criminal trial starts, etc. And yeah, perhaps this is the German approach, but I'm not sure. I did not see that we focused on this problem as you did. For me, it's very interesting to see that it is a big problem in other member states. But till now, I do not think so from the German point of view. Thank you very much.
Okay, thank you, Martin. So it is possible that is proceedings applied in with a civil forfeiture, a civil form of confiscation. What is important is that is a confiscation of a criminal proceedings. No,
no,
even if the proceed is the definition in that member states is that is a civil measure, because we have also, for example, civil recovery, civil forfeiture, but in the practice, they are a form of confiscation of criminal proceedings. No.
As I said, it must be in the context of a criminal proceeding. But at the background, I think, of the German legislator and the judges is that normally a criminal court decide on these aspects, on these measures of freezing, confiscation, seizure, etc. Then it's very clear, but it's not necessary. I think, for example, it's possible that if there is a special court which is deciding on criminal matters as well as on seizures. For example, I've seen in Latvia there is a special court which is has the competence to decide in economic criminal cases, for example, money laundering. On the other hand, it has the competence to use orders for seizure or freezing, and so I think this is not a problem from the German point of view. The only problem is if a classical civil court or more an administrative court is setting such a measure. In these cases, I think the German courts will not accept the measure, but they say
even if it is a measure against proceeds of assets which derives for crimes.
Yeah,
This is the
yes,
problem.
I think this is, yes, I know, but we want to impose we have to implement the obligations of the regulation. And as I understand the regulation, in these cases, if it is only a civil measure, then it's hard to say there is an obligation made by the regulation.
This is, Martin, in my opinion, the problems, because in my opinion, when we speak about a civil or administrative proceeding in the regulation, we speak about a proceeding for the civil, a civil, for example, measure, but which is there is a form of expropriation, a form of confiscation, but without connection with the crime. So for a social to build a new street, no, only for not connected with the crime. But we can have case where there is this definition, civil court, civil proceeding, but it regards deal with asset which derives for crime, which are instrument or proceeds of a crime. So in this case, it is possible to apply the regulation or no? In my opinion, or in my opinion of me, yes, because what is important is the link with the crime. And the other problem is also the safeguards of this proceeding in order to ascertain, to establish that is proceeds of a crime. This is the other big problem, no? The link with to establish this link with the crime, to in which way the court has established that is proceeds or instrument of a crime.
Yes and no. I think the wording in the reasoning of the German legislator is that it must be in the context of proceeding in criminal matters, im Rahmen von Verfahren in Strafsachen.
Yeah.
This is the reasoning behind the legislation to implement the regulation. And it is not very clear what this means. So it's open. But if there is a strict connex to a pending criminal case, for example, that a civil court is imposing measures parallel to the pending criminal case, then perhaps it's not a problem, because then there is a connex. But if we only say perhaps the money or whatever is the result, is the fruit of a crime, but there is no criminal case and no criminal procedure, I said it is different, because our non-conviction based confiscation, for example, is up to the criminal court. So it is a criminal procedure in our eyes,
Yes.
despite of the fact that there is no crime and no criminal, but it is money or benefit most likely as the result of a crime. So I think if it is a civil court basing on the private law, deciding that we should freeze, for example, money or whatever, then I think there must be a clear link to a criminal case, and it's not enough that the civil case is responsible to decide, for example, on a non-conviction based confiscation without any criminal case, or in cases in which it is impossible to use criminal law because of insanity of the person or whatever. So yet that's when I say yes or no, it's perhaps it's a different background, and the background in Germany is that we use criminal courts to make measures, provisional measures, for example, on freezing, and in this cases perhaps we do not, and we use it for the third party confiscation. That means if you want to confiscate or freeze money, which is the profit of a firm or whatever, then it's up to the criminal courts, despite of the fact that it is not possible under German law to accuse the firm for a crime. So this is the background. I cannot exactly say what will we do if, for example, the Netherlands use only civil law or private law, and the courts which are competent only for the decisions on the basis of civil or private law. I do not know whether there is a case at the moment, but I think it would be problematic. In other, as I know, I said the example of Latvia, it's different because they have an economic court which is responsible for economic cases and economic crimes as well, and they are responsible for making, as I said, provisional measures, freezing, confiscation, and so on. And I think it's very clear that we accept this freezing or confiscation orders on the basis of regulation. But perhaps we must discuss it case by case. It's not easy to answer it because of the different background, I think, in the different countries, different member states of the EU.
Okay, thanks so much, Martin. Okay, welcome to Professor Balsamis Mitsilegas, which is our member of the monitoring board, and is also an expert of European criminal law. Thank you, Balsamis, also for your for having accepted our invitation to be a member of our monitoring board. Now I give the floor to Jan-Lise de Boer. Jan-Lise de Boer, please.
Yes, thank you. Thank you. I'm also representative of the Netherlands. And I would like to first say that at this moment, the Netherlands does not have a civil or a non-conviction based procedure, which is effective and used. So at this moment, we have two forms of confiscation that in our law fall under the scope of the regulation of 2018, and that is one conviction-based object confiscation form, and the other is a conviction-based and value confiscation form. For those two types of confiscation, we also have two types of freezing in our legislation, and also those are criminal forms of freezing of assets. When we are on the receiving side of the regulation, even under the framework decision of confiscation from 2006, we had no problem with non-conviction based forms of the form of Italy, for instance. We have recognized that also under the Strasbourg Treaty, but also under the framework decision of 2006 on confiscation, we have recognized the confiscation orders from Italy. We do have a debate nationally about non-conviction based confiscation and our debate is we're working on new legislation for non-conviction based confiscation, and that's a sort of hybrid form of confiscation where it is a civil procedure. But I would like to stress, if it concerns confiscation in relation to criminal offenses, in my opinion, it could never be a civil matter. Even if it's a civil procedure, it can never be a civil matter in the context of European law, because European law already states in Regulation 44/2001, civil matters would be between two equal parties. And if you come to the concept of confiscation for criminal in relation to criminal offenses, then it's not equal parties. It cannot be your neighbor confiscating your illegal assets. It's always the government versus either a natural or a legal person. So it's not two equal parties, and it's just never a civil matter. So the discussion is not whether it's a civil matter. That would be also always be outside of the scope of the regulation and confiscation as we talk about. But we do believe, and Ms. Maguri already mentioned the Bellas case from the European Court of Justice. There's also a case that is 150 from 2021. It's also about the framework decision on financial penalties. And in those two cases, there's the European Court of Justice already said that proceeding in criminal matter can be decided by any court of tribunal. So it can be a civil court, it can be an administrative court, it can be a criminal court. But then it's important which elements are part of the procedure. Just which role does the judge have? Can he assess the whole case? Which protection has the person concerned? So does he have the right to appeal? Does he have the right on information? Does he have the right for translation and information about the case? So these elements of the procedure are important to decide whether or not it could be a procedure in relation to criminal matters. Then the elements of a criminal proceeding should be present in the proceeding, and then it can be a proceeding before a civil court or before an administrative court. Our debate, the problem where we mostly have our debate on, is not the concept of criminal matters, but when is it actually a proceeding in relation to a criminal offense? And this is in context with two decisions from the European Court of Justice in relation to the Bulgarian civil confiscation, before that commission that can make civil confiscation orders. And then it's, amongst others, the decision from 2018, case 234 from 2018, where the European Court, in relation to the framework decision 2005-12, made an assessment whether or not the Bulgarian form of confiscation would fall within the range of that framework decision, and then it decides it does not fall within the range of the framework decision because in that confiscation proceeding, there's not a subject either. The finding of the criminal offense is not a part of the procedure. So then it's directly linked to the definition used within the European Union. What does confiscation mean? And confiscation is a final decision by a court or a tribunal in relation to a criminal offense to decide that property should be confiscated. And the relation to that criminal offense, in my experience, the problem, the discussion in the Netherlands is especially specified to that part, whether the relation to the criminal offense is present if the criminal offense, the finding of the criminal offense, is not subject of the proceeding itself. And that is linked to when there's not a conviction in that proceeding, then yes, there is a context, because you say we confiscate illegal profits. So there is a link to a criminal offense, but it's not. To what extent is that part of the proceeding? And that is the main issue where we have a problem when we're debating about this subject. And I would like to stress, for us, it's not really a debate in when we receive orders from other countries under the regulation, because in that case, our main finding is that it's up to the issuing authority to assess whether or not that form of confiscation in their country does fall within the reach of the regulation or not. And we should foremost trust the assessment by the other country, by the authorities from the other country, that they make that the right assessment, that they can issue an order for this decision. So we would execute if we receive non-conviction based decisions from other countries. But yes, we do have a debate about whether or not which forms of, especially within the range of the discussion about our new legislation, which is not in force yet, so we're not using it yet. Would that fall within the range of a criminal proceeding in relation to a criminal offense? So I hope I made myself clear here.
Thanks so much. So I suppose that also our next meeting about the different models of confiscation will be interesting for Netherlands, no? In order to verify which are the different models of a non-conviction based confiscation, no? For your debate about the possibility to introduce a new form. Also in the new directive, the new proposal of the directive, there is this idea to introduce, to impose member states to introduce a more extended form of non-conviction based confiscation. So it is important. But it's interesting to understand that in the Netherlands, the approach is to apply, to recognize the form of non-conviction based confiscation which are issued by other judicial authorities, foreign judicial authorities. So this is interesting because I suppose also for Italian preventive confiscation, because in Netherlands there is this problem to apply preventive confiscation against Ndrangheta in particular. Spezia will talk also about this aspect. Okay, we can carry on with other delegation. Okay, from Romania, Colonel Virgiliu Călinescu is present. Yes, I saw before. Călinescu.
Hello.
Hello. Okay.
No,
Edward
is not here.
Okay.
But, thank you very much for your presentation, and it's an interesting matter because I represent Romania at the negotiation of the new directive in confiscation matter, and there is also a problem there because I think your preventive confiscation, it's about the Article 16 from the new directive, and there are a lot of issues there. And of course, in our opinion, it's we agree with the conclusion that if the case is only about the civil or administrative law, it's clear that the regulation is not applicable. But when the safeguards are respected, like in the criminal matter, of course, we think that we need to recognize that order. Thank you.
Okay. 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 Thanks so much. Okay, we have also other partner, but I suppose that is necessary now to do a break or if you agree with me. Okay. We have a break of half an hour, if you agree, or if for me we can also carry on, but I suppose that is necessary a coffee. No? Okay. Okay. We meet 12:30. Okay. To carry on, we will have also the judge, the previous ex-judge, Paolo D'Albuquerque, and we can carry on with our debate. Okay, we see later. See you later.
Bye-bye.
See you later, Ana Maria.
Professore, siamo in pausa.
To our debate, we have a speech, a talk of Antonio Balsamo. He was here before? Maybe he's coming. The other partner, are the other partner here? Oh. Maybe we can wait in some other minutes. Okay. No. Antonio Balsamo is here? Oh. I'm checking. Okay. If Antonio isn't here, we can carry on with our debate. Maybe I can ask Joao Conde Correa. Is here?
Yes, I'm here.
Yes, okay.
Let me put my camera on,
Well,
if I can.
yeah.
Yes.
From Portugal?
Yes. First of all,
okay.
First of all, good morning, everyone. Thank you, Mrs. Ana Maria Malgueri. Thank you for this kind of invitation and this very fruitful debate. I must confess that hearing all the morning debates, I have to say something. Nowadays, we live in a world where criminal confiscation and civil confiscation are closing the gap between both. In the criminal realm, we can see nowadays forms of confiscation that are perhaps worse than forms of confiscation in the civil realm. So it's not a question for me, and I think also from the Portuguese perspective, regarding the regulation is not a question where the confiscation it is done. It is a question of the quality of the confiscation. So we must focus on the guarantees of the confiscation, not on the place where the confiscation is done. To say something more, imagine that in the civil in a civil proceeding, a state confiscates someone because he had a kind of enrichment without cause. In this case, it is purely a civil proceeding. It is purely a civil case. It is not the same if in a civil proceedings, this state confiscates something related to the crime. And if this kind of case has also some kind of guarantee similar to the criminal proceedings, I think taking into account the regulation, but also taking into account the Strasbourg Convention, Warsaw Convention, I think Portugal should be able to recognize it and to execute this kind of confiscations. The problem is, for me, is now in the new forms of confiscation, like extended confiscation, because, for instance, in Portugal, we have a kind of extended confiscation that is not related with a crime. We need a crime. It's quite similar to the Article 2014 of the Italian criminal code. We need a crime to put this mechanism in order, but the confiscation is not related to the crime. So the problem is here, not in the cases where there is a crime and the link between the crime and the assets is proved, either in a civil proceedings or in a criminal proceedings. So we should focus more on the guarantees, not on the true nature of the proceedings. Saying that, I must say that we fully agree with what you said previously this morning, and also with Jean-Louise said this previous morning, because the main point is this: we should pay attention to the quality of and the guarantees of the proceedings, not where it is done. Thank you very much.
Thank you. I agree, absolutely. And now Antonio Balsamo is here. No, it's strange. I can try. In any case, we have another partner, France, Ministry of Justice, Véronique Doucet or Arnaud de Blesson. Here, somebody from France?
Yes, do you hear me?
I am not able to see you.
Yeah.
Antonio is here. Okay, Antonio, a moment, and we conclude this first round of contribution interview, and after we give you the floor. Okay.
Thank
Arnaud,
you so much.
please.
Yeah, thank you very much. First of all, I'm very pleased to meet you all. I was not here in December for your first meeting in this recovery project, but now, I have the ability now to participate in this recovery project. So I'm very pleased with that. Just to tell one or two things about the French national legislation regarding the forfeitures and also the freezing orders. So our system, of course, is civil law. So it's based on conviction. Sorry. So we have we see at the level of our office, which is the Office for Mutual Legal Assistance in the French Ministry of Justice, we have the ability to receive the mutual legal assistance requests that request the confiscations or freezing of some assets. So for European Union or for non-European states. So the interesting thing is that we have that vision of these two sides. First, the freezing and confiscation aspect for European Union and for non-European Union states. And which is interesting is that in France, you cannot have the forfeiture of assets without a conviction, a criminal conviction. But it is possible to execute MLA requests from a European Union member to execute the forfeiture without a sentence according to our case law. So this is also interesting to see the benefits sometimes of the of course of the case law in this regard. So regarding the criminal the proceedings in criminal matters, as it was raised also by our colleagues, we have the possibility to pronounce the forfeiture as additional punishment or alternative punishment for criminal or misdemeanors aspects regarding, once again, the proportionality of it, and for very specific measures. So if you have any other questions or anything in this regard,
okay,
feel free to.
Okay, thank you, Arnaud. There was an interesting case in the past in France about the application of the confiscation preventive, Italian confiscation preventive measure. It was in 2002 when the French Supreme Court upheld the decision of the Appeal Court of Aix-en-Provence, which authorized the implementation in France of confiscation issued by the criminal court against of Milan, the tribunal of Milan, against property, preventive confiscation. In that case, because the property was considered the product of a money laundering from drug trafficking. It was very interesting, the arguments of the court, perché the French Supreme Court, the court based this decision on the fact that pursuant to Article 12 and 14 of the Strasbourg Convention of 1990, mutual assistance was required, the confiscation order was final and enforceable, the French law provided for the confiscation of the proceeds of drug trafficking and subsequent money laundering activities, even if with other instruments, also with the general confiscation, no? Against drug trafficking and money laundering. And the last argument, the French legislation doesn't require the same legislation, because the same demands the same legislation. Stressed the court would mean the risk of hindering any cooperation. So this case was very interesting, and there was also the opinion of the Senate Justice Commission, which was favorable to the application of Italian preventive confiscation in the French system of law. So it was one of the first case of application of preventive confiscation in France. Okay, before to give the floor to Lithuania, I would like, because to give the floor to Antonio Balsamo, because he has also problem of time. I know that he has been very...
No, don't worry. We can give the floor to Lithuania without any problem, please.
Yeah? Okay, so we can end our first round. From Lithuania, we have Jūratė Radisauskienė. Oh, sorry for my pronunciation. From Lithuania. Okay, yeah.
Yes, good afternoon, everybody. Thank you for giving me the floor. My name and the second name were pronounced very well, very nice. Thank you for that. And what can I say? We have in our criminal code two types of confiscation: classic normal confiscation and extended confiscation. This means that we can work within the framework of regulation. And what is interesting, that Lithuania in 2020 adopted law on civil confiscation, and it is possible to have civil confiscation in cases in cases that were terminated, or person which were acquitted, and so on. And in case there is a list of particular crimes, and also it is in relation to organized crime. But what we see in our practical life, we have started cases of civil confiscation, and now we have obstacles to trace assets within European Union, and we don't know how it will be in the future.
Okay, thanks so much. Now, it is my pleasure to introduce Antonio Balsamo is the president of the Tribunal of Palermo now, but he has a long career. Has been also international judge of the Constitutional Court Chamber of the Kosovo, Specialist Chamber. He was Deputy Prosecutor General of the Supreme Court of Italian Supreme Court. He was the President of the Court of Assise and of the division competent for patrimonial preventive measure, also in the Tribunal of Caltanissetta, not only in Palermo. Also judge in the Supreme Court. It is very important, was legal advisor of the permanent mission of Italy to the United Nations, and member of a human rights review panel in Kosovo, and so on. So he is a very expert in the fight against organized crime. He was also a member of the Cards to Wing project, Fight Against Organized Crime, Corruption, Unity, Public Prosecutor Office for the former Yugoslav Republic of Macedonia, and so on. So he's really an expert on this topic, and so thank you so much for taking part in this workshop. As an expert, dear Antonio, I give you the floor. Please. Today, Antonio will speak about the safeguards which the regulation wants to guarantee. Please.
Yes, thank you so much. It is a great pleasure to participate in this very interesting meeting. I would like to thank Professor Anna Maria Maugeri and all the organizers for their kind invitation. And I think that the meaning of proceedings in criminal matters is very significant because obviously it implies the definition of the scope of application of the regulation with reference to a plurality of states, a plurality of legal systems. Because when the regulation in the recital number 13 states that it should apply to all freezing orders and to all confiscation orders issued within the framework of proceedings in criminal matters. Immediately after this first statement, there is an important clarification that the proceedings in criminal matters is an autonomous concept of union law. Interpreted by the Court of Justice of the European Union. And I would like to add, interpreted by the judges of the single member states. And obviously, this meaning is clearly connected to the law in action. And the judicial experience we have made so far clarifies that the regulation may cover also the main form of non-conviction based confiscation, which is typical of the Italian legal system, namely the asset prevention measures, because there are specific cases in which a freezing order which is included in asset prevention proceedings has been enforced abroad based on the regulation. And this has an important implication in terms of procedural guarantees applicable, because we have to build a concept of procedural guarantees that may include both criminal proceedings stricto sensu and other forms of confiscation which are not criminal in itself, but can be treated in such a way to fall within the scope of definition of proceedings in criminal matters, even if they don't have the same procedural rules that are applicable to criminal proceedings stricto sensu. And just to put in practice this general approach, I would like to mention the specific features of the proceedings for the application of non-conviction-based confiscation in Italy, which are without any doubt the most relevant area of application of the new regulation. And we have to clarify that under the Anti-Mafia Code, the asset prevention measures are ordered by a criminal court, but following a specialized trial on assets, which does not need a conviction as a prerequisite, and has a more flexible structure than criminal proceedings. However, we will clarify that also these proceedings are characterized by the procedural rights that are typical of the proceedings in criminal matters under Article 6, paragraph 3 of the European Convention on Human Rights. What's the reason for this specialized trial on assets? Because it is important to understand that these proceedings can occur independently of any related criminal proceedings, and non-conviction-based confiscation is pursued not only after criminal proceedings are abandoned or are unsuccessful, but also in parallel to the related criminal proceedings. However, these separate forfeiture proceedings, compared to the civil proceedings for confiscation, which are typical of common law systems, have the important advantage of the opportunity to make use of several tools available for investigations in criminal matters. And these proceedings are marked by a high standard of proof, because they require a rigorous demonstration either of the illegal origin of the assets, which should constitute the proceeds of illicit activities or their investment in companies, real estate, or other goods, or of the disproportion between accumulated assets and lawfully acquired income. The collection of evidence is developed in depth because these proceedings are based on the joint assessment of accomplice evidence, the statements of the so-called collaborators of justice, financial investigation, and electronic surveillance. And these proceedings, moreover, involve a close cooperation between the judicial authorities and other institutions, such as the Bank of Italy. So this system of asset recovery, which is typical of Italy, combines the two aspects of efficiency and guarantees in such a way that they reinforce each other. And this is been described by prominent scholars as a significant expression of the development of a multidisciplinary and evidence-based approach aimed at countering the economic dimension of the most serious criminal phenomenon in a new globalized context, where financial dynamics transcend national boundaries and drive legal structures towards an entrepreneurial rationality, which makes them largely immune to judicial proceedings related to individual offenders. This is an important reason in favor of this typical specialized trial on assets. We have to clarify, in addition, that according to the case law of the European Court of Human Rights, the proceedings for the application of asset prevention measures, the so-called prevention proceedings, do not involve finding of guilt, and so should not be covered by the third paragraph of Article 6 of the European Convention of Human Rights, which concerns the right of the person charged with a criminal offense. They should be covered only by the first paragraph of Article 6, which, however, protects an extensive and sophisticated body of rights, summarized as the right to a fair trial in both civil and criminal procedures. But the Italian law in action has extended to prevention proceedings the most important additional convention rights provided for criminal trials, such as the rights of the defendants to be in court, to be informed promptly of the details of the charge against him, to adequate time and facilities to prepare a defense case, to effective legal assistance, which must be funded by legal aid if the defendant cannot afford it, to question prosecution witnesses, and to call and examine defense witnesses under the same conditions. As a result, we have to understand that the indication contained in the new regulation may be also interpreted in the light of the law in action, and precisely as a law provision that requires the extension also to non-conviction based orders of confiscation and seizure of all the guarantees that are required by the European Court of Human Rights under Article 6, paragraph 3, even if if the domestic legislation could be interpreted in a more restrictive way. The interpretation that derives from the regulation, and which is a condition for giving these orders the opportunity to make use of the new potential, which is typical of the regulation, implies that all of these proceedings, which are not based on a conviction, should, however, include the application of the main convention rights. I think that this approach does not underestimate the specific nature of these proceedings. Instead, it is a specific implication of the general approach according to which, in the area of asset recovery, the main guarantees and the main instruments typical of a criminal procedure may help the development of proceedings that go in depth, that go beyond what has already been ascertained, And I think that just this was the aim of people who introduced in the Italian domestic legislation this new form of confiscation. They did not try to reduce the scope of traditional guarantees. Instead, they tried to understand how a state recovery could be enforced not only in connection with the finding of guilt, but also as a principal field of research, of evidence, and of uncovering the economic dimension of crime. So I can express what is the balance that has been reached within our domestic legal system with a reference to procedural rights connected to proceedings in criminal matters as extended to not only to criminal proceedings, but also to asset prevention proceedings. First of all, we have tried to take very seriously the right to remain silent and the privilege against self-incrimination. The starting point of the development of asset prevention proceedings is closely connected to this guarantee. No one is compelled to answer questions during interrogation, it is obvious, but in any case, no one is obliged to produce evidence of documents or to provide information which may lead to self-incrimination. We have only imposed a normal burden to indicate the facts that may give rise to doubts against the approach developed by the public prosecutor and by the investigating authorities. We call it a burden of allegation. It is not a burden of proof. And as a consequence, also, the problem of the presumption of innocence can be addressed properly because the Italian case law has not extended the presumption of innocence under Article 6, paragraph 2 to this form of no conviction based confiscation. But as to the way of addressing the values at stake, we have a clear rule of judgment, which implies that the burden of proof is on the prosecutor.
Antonio, non ti sentiamo più. Antonio?
Only. Yes?
No,
sì?
we don't have.
Can you hear me?
Yes, now, yes.
Okay. Thank you so much. We have only admitted the use of a presumption of fact or presumption of law. But these presumptions are confined within reasonable limits, which take into account the importance of what is at stake and maintain the rights of the defense. In particular, we have tried to enhance the importance of the connection of time between the criminal conduct and the proceeds to be confiscated. So the presumption of a fact and of law, which is typical of the idea of disproportion between lawful income and value of the assets that are owned by the accused person has been interpreted in such a way to be consistent with the presumption of innocence as a rule of judgment. And moreover, we should consider that the presumption of innocence operates as a rule of treatment, because it prohibits that the accused person may be considered or treated as guilty during the proceedings before his guilt has been established by a court. I think that also this dimension of the presumption of innocence has been applied because every time we take into account the independence of non-conviction-based confiscation from criminal proceedings, we also add that the acquittal in criminal proceedings is an important factor to be taken into account for the opening and for the conduction of asset prevention proceedings. The prevention proceedings should include, in any case, also the collection of evidence that go beyond the evidence collected in criminal trials. So we cannot have two different findings in these two proceedings, unless there is a new and relevant collection of evidence that may justify a different conclusion as to the economic dimension of a crime. There is another important implication of the presumption of innocence, which is the need for avoiding the risk of stigmatization. I think that in this respect, the Italian experience is a good example because the statements made by the public authorities have always been the outcome of an approach based on a high level of prudence. No finding of guilty, nothing that may determine the public conviction of the involvement of accused person in a criminal context has been spread within the community, unless a specific judicial decision has been held previously. So even if the presumption of innocence is not formally applicable to this form of proceedings, in any case, the main implication of the presumption of innocence have been taken very seriously. And I think that this can be an important principle under which to strike a proper balance between the competing rights that are relevant for all the proceedings covered by the EU regulation. As to the further implication of the third paragraph of Article 6, we have tried to establish the right to a full and detailed information concerning the charges, just with reference both to the material facts alleged against the owner of the assets and the legal qualification of these material facts. We have different so-called types of dangerousness that justify also the non-conviction-based confiscation orders, and that have to been indicated since the beginning of the proceedings. Obviously, it is possible to give a new legal characterization of the acts on which the accusation is based. But every time we try to ensure adequate time and facilities to react to a reclassification of facts and to organize the defense on the basis of any new information and allegation. There are also some important implications of this right, such as the right to access the case file, based on the principle of equality of arms. The right to access to the case file has been applied fully without any restriction. And in addition, we have tried to ensure that the decision-making procedure is based on all the evidence adduced by the defense. This is also another, the other phase, the other side of the same right. As to the right to have time and facilities to prepare the defense, I think that the domestic legislation has also reached a good balance because the prevention proceedings do not are conducted within a specific time limit. But this time limit is certainly enough to allow the defense to avail time and facilities for the presentation of the evidence which may be relevant to the case. As to the excuse me, as to the right to call and cross-examine witnesses. In this respect, a distinction should be drawn. The domestic legal system of criminal procedure has introduced additional guarantees, which are not required by Article 6, paragraph 3, letter D of the European Convention of Human Rights. As you all know, the principle is, according to the definition given by the European Court of Human Rights, is consistent with the opportunity to use as evidence also the previous statements of witnesses, provided that some counterbalancing factors are ensured. Including the existence of strong procedural safeguards, so to permit that a fair and proper assessment of the reliability of the evidence can take place. In the domestic criminal procedure, however, there is a general rule under which only the statements made at the trial can be used as evidence in criminal proceedings. This rule has not been extended to asset prevention measures. However, the law in action is fully consistent with the case law of the European Court of Human Rights, since it allows the use of previous statements made by the witnesses only when the cross-examination of the same witnesses is accorded only when the defense has the possibility to call and to examine the witnesses whose statements have been previously collected by the public prosecutor. So even if the rules about the collection of evidence are different between criminal trials and asset prevention proceedings, both of them are consistent with Article 6, Paragraph 3, letter D of the European Convention as interpreted by the Strasbourg Court. So in such a way, the principle of equality of arms between the parties has been implemented. In such a way, it is possible to obtain a flexibility of prevention proceedings, but at the same time to make them fully compliant with the principles of the European Convention of Human Rights. We have also tried to ensure the right to an interpreter and to translation, even if the case is concerning foreigners are not so usual in our legal system. We have also fully applied the right to be present at trial. Trial in absentia are admitted at the same conditions under which they are possible for criminal proceedings. And in any case, in full compliance with the principles set out by the European Convention of Human Rights. Just to summarize, we have tried to adopt all the guarantees that are typical of the European and international legal framework on proceedings in criminal matters. What's the future? In my opinion, it is connected to the implementation of a very important judgment that has been issued by the European Court of Human Rights just in 2021. It is the judgment of 13 July 2021 in the case Todorov and others versus Bulgaria. This judgment sets out the culture of evidence and the procedural guarantees that, in my opinion, should be at the basis of the full implementation of the guarantees of criminal proceedings within the area of seizure and confiscation. In particular, some factors that are indicated in this judgment are very significant. For example, the possibility of adopting less restrictive alternative measures. This is the rationale behind our choice to set out in parallel to seizure another form of intervention of assets, which is the so-called judicial control. The judicial control makes it possible to ensure the implementation of the goals that are typical of asset prevention measures without depriving the owner of his or her properties. And it is an important development of our asset prevention system. In other terms, there are two main avenues that could be experienced. The first one is the traditional way of understanding the meaning of asset prevention by means of seizure and confiscation of assets. The second one is a control which is under the supervision of professionals appointed by the judge that are entrusted with the task of remove every connection between a company that has been paid attention by the investigating authorities and the criminal environments. It may result in the imposition of a specific prescription aimed at removing every infiltration of organized crime in the economy with a specific reference to that company that is located in a sort of gray zone. The second the second factor to be taken into account is the nature of the measure, because it has been underlined in the total of judgment that the lack of every limit may be inconsistent with the principle of proportion. And the third factor is the connection between the criminal conduct and the assets to be seized or confiscated. These general ideas has been put into practice by the European Court by making reference to specific features of the proceedings. For example, the demonstration that the owner of the assets has committed a specific crime. The specific assessment of the goods to be confiscated. In particular, the European Court has required that a connection between the owner of the assets and the illegal acts that have been ascertained should be found without any reasonable doubt. And it is also important to understand that a wide scope of application of seizure confiscation measures may be in a problematic relationship with the principles set out in this judgment. In any case, it is important to identify crimes that generate income that can give rise to the production of proceeds. When it is impossible to make a presumption that the crimes indicated in the domestic law as the basis for confiscation generate income, the domestic legislation may be in violation with reference to the total of judgment, in violation of Article 1 of the first protocol. But more generally, in my opinion, it is in violation of the main implication of the presumption of innocence. Namely, the presumption of innocence as a rule of judgment, a rule of assessment of the evidence. Another important implication is the scope of the time limit of the confiscation measures. In this respect, a reasonable connection of time between the ownership of the assets and the commission of criminal activities is a precondition for the admissibility of those presumptions of law and fact that are admissible under Article 6, Paragraph 2 of the European Convention of Human Rights, but only within specific limits. And in such a way, I think that it will be possible to obtain an harmonization of the domestic legal systems concerning seizure and confiscation, because I think that the efficiency of the EU regulation is dependent not only from formal qualifications, but in addition, and I think mainly, on the opportunity to understand the similarity between the different types of seizure and confiscation, despite on their formal qualification within the single domestic legal systems. And I think that just the judgment of the French Supreme Court that has been mentioned before, that one issued in the Crisafulli case, is a typical example of this cultural approach, because the French Supreme Court found that the asset prevention measures, which are typical of the Italian legal system, but were unknown in the French legal system, nonetheless presented the same features that were typical of the intervention of on assets in similar conditions under French domestic law. And such an awareness helped in a relevant measure the efficiency of international judicial cooperation. In my opinion, the same rule could be extended to the implementation of the EU regulation. So that my suggestion is in favor of a mutual awareness and knowledge of the types of confiscation, which can be seen both as the source of a harmonization of the different legislation and as a powerful factors to increase the effectiveness of the EU regulation. Thank you for your kind attention, and I'm available for all the questions you would like to raise.
Okay, thanks so much, Antonio, for this so rich presentation, which has given us a broad view of the possible application of safeguards. I have a lot to say about your opinion, because I will only to stress the importance of jurisdictionalization in the application of this form of confiscation. You have given your presentation of the procedural safeguards in the Italian system of law is very positive. Is a system with the guarantee of the Article 6, number 1, Article 6, number 3 of the European Convention. You talked also about the application of the presumption of innocence as rule of judgment. This means that in some way we have to apply the criminal standard of the proof But in the practice, is really so? In the practice, we have a real contradictory between the prosecutor and the defense in the proceeding to apply the preventive confiscation. We have really all these safeguards guarantee, which is the real standard of the proof. In the opinion of many lawyers, the standard of the proof is not the criminal standard of the proof, is lower. I suppose that we have a lot to debate. Your finding is very interesting for our research, because what is sure is that, in my opinion, but we have to we have to do this choice together with the other partners. Your pending of the safeguard, of the guarantee, of the procedural guarantee, of the also the application of the principle of proportionality and so on, it has to be the aim, no, the goal, that it is the model of also non-conviction based confiscation, the proceeding criminal matter has to reach. I am not so sure that in the practice we have the application of all that is guarantee. Okay, I don't know if what we have to speak about this guarantee, this system. Now, after we can carry on to debate about this aspect, very important for our research of the guarantee. But now, if we don't have some specific question for Antonio, I would like to give the floor, because he also has not a lot of time, I know, to Paolo Pinto, Professor Paolo Pinto de Albuquerque. I thank him for having accepted our invitation to take part in this workshop. Paolo Pinto de Albuquerque, I suppose that everybody knows who he is, but in any case, I would like to remember that he has been was judge of the European Court of Human Rights from 2011 until 1 year or 2 years ago. Between 1992 and 2004, he sat on the bench of different courts in Portugal. Since 2015, he is professor catedrático at the law faculty of the Catholic University of Lisbon, where he teaches criminal law and procedure, penitentiary law, public international law of human rights, and the philosophy of law. He has published widely in this field of law. He has been visiting professor in the United States, China, and addressed the audience in Angola, Belgium, Brazil, France, Germany, Italy, Portugal, Spain, Switzerland, Turkey, and so on. And he has worked as an expert for the Council of Europe and the European Commission of the European Union. Paolo, thank you so much for your participation. The topic of Professor Albuquerque is the interpretation of this concept of a proceeding criminal matter in the case law of the European Court of Human Rights. I would like to remember that the approach of the European Court of Human Rights is not always so guaranteistic. No? In many cases, the court has not included in the concept of proceeding criminal matter different form of proceeding in order to apply form of non-conviction based confiscation, also for the Italian preventive confiscation. And Professor and the Judge Albuquerque has gave some dissenting opinion, very famous dissenting opinion. So, Paolo, I give you the floor. Thank you so much. No, Paolo, we are not able to hear. No, we don't hear. Maybe.
Can you hear me now?
Okay.
Good.
Now it's possible. Thank you.
Grazie mille for this invitation, dear Anna Maria. Thank you so much for this kind invitation. It's a pleasure to be with you, to meet again, although by means of this not so personal link, but it's always a pleasure to discuss these issues with you and the colleagues. I see Antonio, I see Giovanni, and other colleagues. It's really great to see you in good shape, in good health, and always ready to discuss these important matters. Now, what I intend to do very briefly is to remind you of the very problematic case law of the court in this regard. The court has approached these issues from three different perspectives: Article 1, Protocol 1, Article 6, and Article 7. Sometimes it has dealt with confiscation under two or more of these articles. And the results are not always consistent. We see that, for instance, in GM, the way the court deals with confiscation under one article would imply a certain solution under another article, yet the court does not take this further step. So there is an internal inconsistency of the judgment of the court, because the court is not willing, mainly for political reasons or judicial policy reasons, is not willing to take this additional step. I have tried to describe and analyze the case law of the court until Varvara is a very important judgment against Italy. And I wrote separately, trying to sum up basically the main problems of inconsistency of the case law of the court. In that case, under Article 6. But I also mention the other two articles relevant in this regard: Article 1 of Protocol 1 and Article 7 of the Convention. Now, let me start by saying that confiscation measures have been referred to and dealt with in the case law of the court, both with regard to productum celeris, means the product of a crime, like, for instance, the famous Gokititze and others versus Georgia, Silikieni versus Lithuania, or Phillips versus United Kingdom. These are the products of a crime, and they are confiscated as such. Or the object of a crime, objectum celeris, and these you have instances like Agassi versus United Kingdom, Ismailov versus Russia. Here, the purpose is really to take out of the market a certain object that was used as the means of a crime. And of the instrumental salaries, meaning the goods, the assets that have served or could have served for the practice of a crime. Here you have, for example, all the cases regarding Macedonia or Romania, like, for instance, cars that have been confiscated that were used for trafficking people or trafficking drugs. This is the classical, so to say, confiscation that can be found in any criminal code. But you have also cases of confiscation where there is no connection to the practice of a crime. Like, for instance, Todorov versus Bulgaria, Marcos versus Latvia, Rumi versus Estonia, Göring versus Netherlands. And here is starts the problem. When there is no connection with regard to a particular crime, then we may enter into murky waters, and we probably have left the classical confiscation and are faced with the cases so-called non-conviction based confiscation, because they do not suppose a previous condemnation on the basis of a guilty offense. The court under Article 1, Protocol 1 has dealt with these different types of cases, which I will later on try to define a little bit more. Has dealt with them under Article 1, Protocol 1 as means of control of use or as means of deprivation of property. We know that Article 1 of Protocol 1 requires that any interference with property must comply with 3 requirements, basic requirements: lawfulness, proportionality, and public interest. Why is there an interest in separating means of control of use of property and means of deprivation of property? There is a major practical relevance of this difference, which is, and the court has stated repeatedly, which is that the margin of appreciation of the state is different. When we talk about control of use of property, the margin is larger, is wider. When we talk about deprivation of property, the margin is less wide, is much narrower, okay? This is relevant in practical terms because the court here, with certain consistency, has used a stricter standard of evaluation of the proportionality or the interest, the public interest, when there is deprivation of property, and has accorded a wider margin of appreciation while assessing proportionality and the public interest when there is a measure of control of use. So this is the first big dogmatic. It's a dogmatic relevance of and practical relevance of a different standard used by the court. Now let me pass on to the core of my speech today. And is related to that type of confiscation that I mentioned previously, confiscation that are not necessarily connected with the practice of a crime, the so-called cases of non-conviction based confiscation. The practice of the court has identified 4 groups of cases, okay, of non-conviction based confiscation. First group, confiscation within a criminal procedure imposed on third parties which means people that are not parties to the criminal conviction, to the criminal procedure. So the first group of non-conviction based confiscation is a confiscation measure imposed within the criminal procedure. There's a criminal procedure pending, but it is imposed not on the convicted person or the suspected. It's imposed on a third party, a person that has no link to the crime, no apparent link to the crime. Okay? This is the first type of case. And you find these, for instance, in GM. You find this in Telbezin Viziteu versus Romania, Rumi versus Estonia, Vaits versus Estonia, Silikien versus Lithuania, Sudfondi, Ildirim versus Italy. So these are cases of confiscation that is imposed within the criminal procedure, but on third parties. Second type of cases, confiscation still imposed within a criminal procedure that is pending. It is imposed on a person that is a party to the criminal procedure, but this person has been acquitted, or the procedure has been dismissed for instance, substantive or procedural reasons. Okay, the person is no longer accused, is no longer not even a suspect person. The claim of the prosecution has been dismissed, fully or not. It's irrelevant, the reason for dismissal. The important thing is that the confiscation is imposed within the criminal procedure on a person that is a party. This time the person is a party to the criminal procedure, but has been acquitted, or the accusation has been dismissed, okay, or discontinued, for instance, for formal reasons. And here you have the cases of Balsamo against San Marino, Goerings against Netherlands, Saliba versus Malta, Raimondo versus Italy. Okay, all of these cases belong to the second type of non-conviction based confiscation. Third type is confiscation which is imposed in a non-criminal procedure, maybe administrative, maybe civil, whatever, but it is not criminal per se. It's not identified as criminal procedure. But it is imposed on people suspected of the practice of crimes, criminal offenses, okay? So the procedure is not penal, the procedure is not criminal, it's an administrative or civil procedure, but the people on whom these confiscation measures are imposed are suspected of having practiced crimes. And here you have Walsh versus United Kingdom, Webb versus United Kingdom, Butler versus United Kingdom. Fourth group of cases, and final. I'm always referring to non-conviction based confiscation cases in the jurisprudence of the court with examples. Confiscation, which has been imposed in a procedure that is not penal in nature, so administrative, civil, whatever, and it is imposed on people that are third parties to this procedure, which have some relation to a suspect person, okay? So they are third parties to the procedure, but they have somehow some relation to the practice of a crime. And here you have Cacucci and Sabatelli versus Italy, Bongiorno and others versus Italy, Perre and others versus Italy, Morabito and others versus Italy, Riella and others, Arcuri and others, and of course the famous Georgian case, Gogitidze and others versus Georgia. So these are the four main groups of cases of non-conviction based confiscation in the practice of the court. Some of these cases have also been dealt, almost all of them have been dealt under Article 1 of Protocol 1, okay? But some of them have also attracted the application of Article 6 and 7, okay? Here is the problem. The court is not always consistent. Sometimes for cases which are identical, which show the same characteristics, the court applies the guarantees of Article 6 and 7, making them as if they were treating them as if they were a matter of criminal law. But sometimes it does not do the same with regard to very similar measures. And here, of course, there's a lack of credibility in the case law. Because if you are not consistent with the guarantees that you accord to the defendant in such a delicate matter, of course, neither the courts nor the defendants all over Europe, they don't know what the court will do, and they lack guidance for the proper application and adequate application of the law. Let me insist on the strict applicability of the Engel criteria. I think according to the Engel criteria, the vast majority of these measures would be and should be dealt under the criminal limb of Article 6. And of course, this would also, in a consistent application of the law, would also require the application of Article 7. So, in my view, the problem lies not with the case law of the court under Article 1 of Protocol 1, which is more or less linear. It has identified these 4 groups of cases, and it has applied more or less strictly the 3 requirements that I have mentioned: lawfulness, proportionality, and public interest, with more or less margin of appreciation for the state, depending on the fact that the measure is considered a measure of control of use or a measure of deprivation of property. And here, the amount of money, the value of the confiscation is absolutely relevant. So the problem does not lie on the case law regarding Article 1 of Protocol 1. The problem lies with the subsequent application of Article 6 and 7, which is not always consistent. In my view, the vast majority of these cases, I refer to the cases of non-conviction based confiscation, these 4 groups of cases that I have identified in the case law, they would require necessarily the application of the guarantees of the criminal limb of Article 6, considering them under the criminal limb of Article 6, including in the cases where there is no formal accusation regarding the person whose assets are being confiscated, like for instance in this first case, when the person is a third party, it's not even a subject in the criminal procedure, but is treated as such. We see that, and we see that in several countries, in Europe, for instance, in Italy also, where third parties to the criminal procedure, they suffer, and they suffer a lot from the application of these measures. The court basically is tempted to deal with these measures applied to third parties which are not subjects of the criminal procedure, but they suffer the measure of confiscation in a criminal procedure. The court is tempted to deal with them under Article 1 of Protocol 1 and say that this is disproportionate. The interference is disproportionate. But then it does not go a step further, and it does not identify also the violation of Article 6 and 7. Because in fact, the Engel criteria would be satisfied in these cases and would require the application of the guarantees of the criminal limb of Article 6 and consequently also the guarantees of Article 7. So this is basically the status quo right now. Unfortunately, GM could have been a good occasion for solving this, and could have been a good case where the court would systematically and consistently apply not only under Article 1, Protocol 1, but also under Article 6 and 7, the same set of guarantees, the same standard of guarantees, but it did not. It did not. It failed to apply the same set of guarantees under Article 1, Protocol 1, 6, and 7. Now we see a very absurd result, is that the procedural guarantees under Article 1 of Protocol 1 are sometimes much richer than the guarantees that the court is willing to accord under Article 6. This is absurd, totally absurd. So the court runs away from the discussion of these measures of confiscation under the criminal limb of Article 6 and then applies the same or even stricter guarantees, even wider guarantees, procedural guarantees, I mean, under Article 1, Protocol 1. So this is really nonsense. It's nonsensical. A coherent and consistent case law would need an application of the same set of procedural guarantees under Article 1, Protocol 1, 6, and then subsequently 7. So in my view, there's still a long way to go. There's still, I would say, an effort to be made in terms of consistency of the court. I don't see a problem in terms of Article 1, Protocol 1, as I said. I see a problem under Article 6 and 7. I see there a problem. I see that the guarantees applied are not sufficient. The court is very, how should I put it, sensitive to public pressure and to the pressure of the states when, for instance, the states argue that a certain measure of confiscation is absolutely crucial for the fight against corruption or the fight against terrorism. Then the court retracts, backtracks, and is not willing to treat these measures under Article 6 and 7. It only applies Article 1, Protocol 1, which is the easiest way out. So it's a very easy way out. It does not discuss the procedural guarantees of Article 6, the criminal limb of Article 6. It only applies the principle of proportionality, and here it considers even sometimes much wider guarantees, both in terms of substantive and procedural law. As I said, I don't think this is consistent. I tried to the best of my ability to change the case law while I was a judge. I did not succeed, but I think the seeds for renovation are already there at the court, and I hope that future colleagues will have more success than I did. I'm happy still that at least in GM we found a violation because the opposite result would send a wrong signal to Italy and to the entire Europe. So at least a violation could have been found, but I think when these measures are, and they are, preventive in nature, but intrinsically punitive, there should be no hesitation in the application of the guarantees of Article 6 and 7, criminal limb of Article 6 and Article 7. What we see that very severe measures are taken by the states and yet they are only dealt under Article 1 of Protocol 1 with the guarantees, procedural guarantees of Article 1, Protocol 1, but not an Article 6, and even less with Article 7. Of course, this is convenient for the, I would say, for the prosecution and for the fight against certain types of criminality, but this, of course, lacks consistency, lacks coherence, and this is not good for the reputation of the court. My hope is that good cases bring good law, and lawyers are attentive and bring these good cases to the court so that they give an opportunity for the court to make good law. Thank you so much for your attention. I'm at your disposal for any queries. I think this is a very important topic that still remains on the agenda, and with initiatives of this sort, maybe we can do a little bit for the advancement of the protection of people that are subject to these kind of measures. Thank you so much.
Thank you, dear Paolo, for your real systematic presentation about the case law of the European Court of Human Rights, which also stressed the problematicity, no, of this of the approach of the European Court of Human Rights, which is so sensitive sometimes to the pressure of the states, to the justification in some case, no, is the aim justify the instruments, no, in some way, the hands justify, because the approach is okay, the fight against mafia, or the fight against drug trafficking, the fight against corruption justify this approach, no, to less safeguards and the effectiveness, no, of this instrument is more important sometimes than the guarantees. First of all, I would like to say others about this case law of the European Court of Human Rights, but first of all, I would like to ask to the other partner, to the other member of advisory board or monitoring board, if they have some issue, question they would like to ask. Nobody. Okay, maybe I can start with the first question for Paolo. This interpretation of a Gogidize case, that is also another case, that the confiscation, the preventive measure, some non-preventive measure, Gogidize case is a confiscation in Georgia against corruption, but it's a non-conviction based confiscation. No? This approach that the confiscation, non-conviction based confiscation, is a compensatory measure. No, this is an approach that we find also in our constitutional court. No, the Italian constitutional court has affirmed that the extended confiscation, the confiscation preventive measure, have the nature of this compensatory nature. Compensatory nature means the aim is to in some way to eliminate the proceeds of the crime. So it is in the Gogidize case the court affirmed the forfeiture of property ordered as a result of a civil proceeding rem without involving determination of a criminal charge is not of a punitive but of a preventive and or compensatory nature. As a distinct function nature from that of a criminal sanction does not presuppose a crime and a conviction, but the scope is only to eliminate the proceeds of the crime. With your this, in my opinion, the confiscation of the proceeds of the crime has a compensatory nature, but only when we are sure that the proceeds are the crime derives from crime, is the proceeds of crime. The problem is that in many cases we apply this form of confiscation without conviction, giving also the stigmatization that somebody is involved in a crime. So it can be a form of confiscation which is applied without conviction, but also affirming that somebody has obtained his assets from crime, is involved in crime, is mafioso or is a drug trafficker or and so on. Is it possible only to speak about a civil or compensatory nature without the guarantee of the criminal matters, in your opinion?
No, of course not. There's always the element of stigmatization, and therefore it's only a semantic trick to say that this is a kind of reparation, that this is the kind of neutralization of the proceeds of the crime. Of course, if you say that these are the proceeds of a crime, and if you take the money from or the assets for someone, you are stigmatizing this person. There's no way out. It's black or white. If you take the money from someone, even if without convicting this person, like in the Georgian case, but you label the person as a suspect, you label the person as someone involved, of course there's stigmatization. If there is stigmatization, there is always the element of punitive aspect. Stigmatization means punitive element. When you stigmatize someone, you are punishing the person publicly. This is inevitable. So whenever you have this lingering suspicion, a suspicion that is lingering over the person, you are already stigmatizing the person. And if you stigmatize the person, you are punishing the person in practice, in practical terms. Of course, you can say, you can always find semantic tricks, like saying this is a way of reparation, a way of neutralizing the proceeds. You can find all sorts of linguistic, semantic tricks. But the fact is, and the case law of the court is very clear about that the element of stigmatization is there, is essential. In fact, is essential, is as essential as the taking of the money. Why? Because it has a general preventive effect. When you stigmatize someone, you are not only targeting that person, but you are also taking profit of a general preventive effect. Everyone will know that that person was confiscated, the assets of that person were confiscated because that person was somehow linked to the practice of a crime. And this has not only a preventive effect, but also in regard to the person itself, he or she, but also with regard to the general community, to the community. So you have all the elements of a sanction, a criminal sanction. You have special preventive effect with regard to that person, stigmatizing that person, and you have general preventive effects. All the community will know, all the community will take a conclusion out of that stigmatization. So you have the elements of that in fact, in classical terms, and I'm talking about classical penal law. It's just applying the classical principle, huh? The ends of any sanction in criminal law. You have the punitive element, the special preventive element, general preventive element. What else do you need? Of course, you can dress this up as reparation, as neutralization, whatever. But this is semantics, absolutely semantics. If you want to be classic, if you want to keep attached to the classic values of liberal criminal law, this is the conclusion. This is a conclusion. It's inevitable. The cases that you find in the fourth group of cases that I mentioned, the Georgian case, Cacucci, Bongiorno, Perre, all of these cases related to mafiosi, all of them are confiscation measures taken outside of the criminal procedure. It's not a criminal procedure. We know it's a kind of preventive procedure. A quasi-criminal, quasi-administrative, whatever, it doesn't matter, but it cannot be identified under strict convention terms as criminal, which are imposed on not only on the suspected persons, but also on third parties suspected of having some relation with the mafioso, like the family relatives or whatever. I'm not disputing that this is very effective. I'm not disputing that. I absolutely agree. These are means that are effective in the fight against mafia and terrorism, but they are not classical. They are not compatible with classical principles of liberal criminal law. They are not. They are not. They do not. They do not. They are treated as they are penal sanctions in nature, which are disguised as non-criminal. This is the problem. So they are not subjected to the guarantees, procedural guarantees of Article 6 criminal limb, and they are not subjected to the guarantees of Article 7, which means that they can be applied retroactively, which means that the presumption of innocence does not apply, all the guarantees of the criminal limb of Article 6. It's very convenient. This line of thought is very convenient. But this has nothing to do with classical principles of liberal criminal law. Nothing. It's a policy that has been put in practice by the state to fight against extreme forms of criminality like terrorism and organized crime. It's the fight for the best possible efficient criminal policy, not for the criminal policy that is faithful to the basic classical tenets of criminal law. And I've wrote that. I'm not saying anything new. I've wrote that. I think that's what I said previously. I think the guarantees should apply. Article 7 and Article 6 criminal limb should apply to these measures. It's trying to hide some from the obvious. When you apply the guarantees, procedural guarantees of Article 1, Protocol 1, but do not go further and do not apply the criminal limb of Article 6, you are not being consistent. You are not being consistent. You do the easy part. You say it's not proportionate, or it violates proportionality, or even it is not in the public interest, or even it is not lawful. You do the easy part, but you do not the hardcore. You do not state the hardcore guarantees of criminal law, criminal procedure, which are 6.2 and 6.3 of the convention, 7 of the convention. These are the hardcore guarantees, which are not sufficiently protected by the case law for purely pragmatic reasons. This is about a pragmatic criminal policy. I understand it is sufficient, but it is not, has nothing to do with classical tenets of criminal law.
Okay. In many cases, also the court has stressed that these measures are proportionated on the basis of Article 1 because they are a proportionate weapon to fight against drug trafficking, mafia, corruption, and so on. And also the reverse of the burden of the proof. In some cases, the court has affirmed, the court reiterates that can be nothing arbitrary for the purposes of a civil limb of Article 6, number 1 of the Convention.
Yes.
In the reverse of the burden of proof on the respondents in the forfeiture proceeding in rem. In civil standard, or a high probability of illicit origin, it is enough, it is legitimate for the relevant domestic authorities to issue confiscation order on the basis of a preponderance of evidence, civil standard, which suggested that the respondents' lawful incomes could not have sufficed for them to acquire the property in question. Proof on a balance of probabilities or a high probability of illicit origin combined with the inability of the owner to prove the contrary, a kind of reversal of the burden of the proof, was found to suffice for the purpose of the proportionality test under Article 1 of the Protocol number 1. So the respect of the, in some way, the presumption of innocence is not a problem of consistency with Article 6, number 2, but with Article 1. If the lower standard of the proof is proportionate to the respect of the property. In many cases, this is the approach of the court. For our debate, Antonio Balsamo, you have said you have talked over many guarantees, no? Of a jurisdictional approach that is very important. But I would like to provocate. In your opinion, it is enough the respect of Article 6, number 1, Article 6, number 3, that means a lot, no? Because 6, number 3 include also many guarantees in a procedural on the procedural point of view, no? To be informed promptly, to have adequate time and facility to the preparation of the defense, to examine or have examined the witness against, and so on, no? Okay, free assistance. But but you, in your presentation, you also quoted the presumption of innocence as a rule of the judgment. But so what means this? Article 6, number 2, the presumption of innocence, is relevant in these cases or is not relevant? This is the opinion of the European Court that, for example, for Italian preventive confiscation, we have to apply, or go to this case, or also for battle case against the United Kingdom, we have to apply 6, number 1, but we have not to apply 6, number 2. Which is your opinion, Antonio?
Yes, thank you, Anna Maria. I think that the presumption of innocence may also be applied. And indeed, it is applied if we take into account the law in action, the real criterion that is at the basis of the evaluations conducted by the court is consistent with the concrete meaning of the presumption of innocence. I think that there has been an evolutionary trend in the jurisprudence of Italy, due also to the increase in the dialogue between the courts. Due also to the influence of important ideas that were adopted by some of the most prominent judges of the European Court, such as just Paolo Pinto de Albuquerque, whose ideas have had a strong impact on the mindset of the Italian judiciary, just based on this evolution. In my opinion, at present, the assessment conducted by the judges when they have to decide on a confiscation, both in criminal proceedings and in asset prevention proceedings, is in compliance with the idea of beyond reasonable doubt. In my opinion, the idea of the preponderance of the evidence is recessive. It's something that belongs to the past. We do not use any longer the criterion which is typical of civil proceedings. If I have to say what I think, I don't know if this distinction has ever been applied in such a clear way also in civil proceedings, because I don't know if civil judges have really adopted an approach based on the preponderance of evidence. But I am absolutely sure that now the criminal courts that deal with asset prevention proceedings adopt a rule of judgment based on the need for proof beyond reasonable doubt. Obviously, there is a possible alternative viewpoint, but now the Court of Cassation has clarified that no superficial assessment is admissible. At present, the Supreme Court has tried to increase the effectiveness of guarantees. And if we go beyond the formal qualification, which are also the heritage of the past, we see that the same rule of judgment applies both to criminal proceedings for assessing the guilt of defendants and to proceedings related to assets. There is also another dimension of the presumption of innocence. That one, in my opinion, should be reinterpreted in such a way to avoid any confusion between criminal proceedings and specialized trial on assets. It is important that every statement makes a specific reference to the nature of the proceedings. However, I think that there is a clear approach based on self-restraint in the way of communicating the functioning of justice related to assets. Probably all the justice in Italy is now going toward self-restraint in communication strategies. But this is even more evident with a reference to trial on assets.
Okay.
So I think that nothing can be against the extension of the scope of application of Article 6, paragraph 2 to asset prevention proceedings.
Anna Maria, if I may, just to add this point, I totally agree with Antonio. Since the court in GM found a violation of Article 6.2 with regard to Mr. Gironda. Don't forget that. There was a violation of Article 6.2 with regard to Mr. Gironda. The problem was that there was no violation of Article 7. How could the court state that there was a violation of Article 6.2 and not find a violation of Article 7? Since the court stated, the same court said, relating the two guarantees, 6 and 7, said if there would be a violation of Article 6, that would imply necessarily a violation of Article 7. This was stated by the court clearly in the general part. Then in the applicability to the facts of that general part, the court was not consistent because it found a violation with regard to Mr. Gironda of Article 6.2, but did not find a violation of Article 7. This is not consistent. It's not consistent at all. So it considered that there was in fact here a measure that would deserve the same guarantees of any criminal sanction, but then it did not apply 7, which is of course applicable to measures of criminal nature. So to sum up, I agree entirely with Antonio when Antonio says that Article 6.2 fully applies to these measures.
Yeah, the problem of the GM case is also the case for maybe not each partner know that case. In that case, was a form of confiscation which is recognized as a criminal sanction, the confiscation against, in the case of illicit building, but the problem was the application of this form of confiscation also when the crime is statute barred, no, after the prescription. That is also a problem, no, with this measure, because in many cases these forms of confiscation without conviction are applied without in some way without the guarantee of the prescription, no. There are in the Italian system of law, it is always possible to start again a proceeding in order to apply a preventive measure. Okay, we have to speak also about this subject. I don't know if Professor Grasso would like to intervene, because he is not so sure that in the Italian system of law the court respect the presumption of innocence in the application of the preventive confiscation. Giovanni, would you like to? Non ti sentiamo?
No, thank you. No, thank you.
No?
No.
Okay, ora, now I would like to know the opinion of the other partners also in respect that is subject, the standard of the proof, the reversal of the standard of proof, and so on. But I would like, before, if somebody want to ask want to do to present a question to Paolo, because I don't know if Paolo Albuquerque and Antonio Basmo can stay.
No, unfortunately not,
yeah.
as I told you.
Yes. Somebody has a question? Francisco, please.
Yes. Well, first of all, congratulations, Paulo, for your really interesting and clear presentation in a difficult matter like this one. I was looking at the regulation, because we are mainly practitioners, we are using the regulation from the mutual recognition viewpoint. In the regulation, there is a specific reference to the case law of the European Court of Human Rights, but in relation to the concept of proceedings in criminal matters in the preamble, in the recital 13 of the preamble. But there is no reference to the European Court of Human Rights in relation to recital 18. And recital 18 is focused on the set of guarantees that are applicable in particular to proceedings in criminal matters that are not criminal proceedings, and I am quoting. In that recital, there is a reference to the set of guarantees that we have in the procedural rights package, the different directives that we have in place in the European Union. My question is it necessary to have the whole set of guarantees, to apply the whole set of guarantees to these other type of criminal proceedings or proceedings in criminal matters that are not criminal proceedings? Because this is going to be very difficult to double check. If we are an executing authority and we have to double check the compliance with this set of guarantees in relation to criminal proceedings in criminal matters that we are not familiar with, because in the case of Spain, we don't have this type of non-criminal proceedings related to criminal matters. And it's difficult for us to evaluate the compliance with the Engels criteria in this sort of foreign criminal or non-criminal proceedings. My question is, wouldn't it be wiser to focus on particular rights, like the right on to an effective remedy, or the right to a fair trial, or the right to defense, that are the rights that are really involved, and the grounds for non-recognition provided in the regulation in Article 8 and 19 are really focused on these particular rights and not the whole range of rights or guarantees. The second question is it a good solution for this situation for the practitioners to rely on the validation? Because whenever non-judicial authorities are issuing these certificates, we have the institute of the validation by a judicial authority, and then rely on, from the mutual trust principle, relying on the validation when we receive this sort of certificates. Thank you so much.
Yeah, to be very simplistic, we face the same problem in Portugal, like in Spain, because we do not have certain forms of preventive confiscation like they have in Italy. So if there is a request of cooperation, of judicial cooperation, or with regard to such a measure, we would face the same problem in terms of controlling the guarantees that are provided, the basic compatibility of these guarantees with the convention. The basic, I'm only talking about the fundamental guarantees like presumption of innocence if it is considered as a measure of criminal nature. You say that should we focus or not on the basic fundamental guarantees? Well, the basic fundamental guarantees are those of Article 6, 2 and 3. These are the basic. These are what the convention considers the basic. Meaning equality of arms in Article 3 between the prosecution and the defendant, presumption of innocence. These are the basic, the same type of time and means for the presumption to work and for the prosecution and the defense to work. These are the basic guarantees that should be complied with. And they are even more important when these requests of international cooperation they come from non-judicial authorities. Like you say, here we should rely on the validation by a judicial authority. Okay, since there is a validation, if there is such a validation by a judicial authority, okay, there's an independent party which has made this assessment of the compliance of these measures with the basic guarantees of the convention. And I'm not only referring to the convention, but also to the Charter of Fundamental Rights, which goes even further in terms of guarantees. My problem here is that I think that confiscation has been upgraded as the most effective means of fighting against organized crime, more effective than any other, and this is correct. In practical terms, it is an extremely efficient means of fighting against organized crime. I agree with that. But if it is so efficient, then it has to be accompanied with sufficient and adequate guarantees. And these can only be those of 6.2 and 6.3 of the Convention. And if these apply, then 7 should apply. Necessarily. As the court stated in GM, you read the general principles of GM, it's very liberal. It's very liberal. It's a great judgment in terms of the general part, the general principles, because it states if there is a violation of 6, that implies necessarily a violation of 7. I won't tell you who was the person responsible for that part. But it is important that is stated there in the judgment. It is very important. The problem was that general principle stated in GM for the first time was not applied in the concrete case at hand by Mr. Gironda. It was inconsistent because the court found a violation of 6.2 and it did not find a violation of 7. So to sum up, my response is yes, basic guarantees should be complied with both by the requesting state and the requested state when there is requests of international cooperation. If this request comes from a non-judicial authority, then a validation by a judicial authority should take into account these guarantees. At least there should be an independent, not necessarily a judge, but an independent assessment of the compatibility of the measure with these basic guarantees of Article 6, 2, and 3.
Thank you. Thank you so much.
Okay. Now, if we don't have other question for Antonio Balsamo and Paolo Pinto de Albuquerque. I suppose that is the moment of our lunch break. We are in delay, a lot of delay. Okay.
I hope to see you soon, lively, not by digital, which is it's always interesting, but it's not so interesting as lively, of course.
Okay.
In persona.
In persona, in
with
Catania.
The possibility of giving you a big hug to Antonio, to Ana Maria, a big hug to also other colleagues joining now today, and remind us of the old good times when we met so many times in Strasbourg and in Italy.
Perfect. We invite you in Catania in the middle of April for our first meeting in presence of our project. Okay, now we have a lunch. Thank you so much to Paolo and Antonio.
I also would like to thank you very much. The meeting was really interesting and challenging. A big hug to Anna Maria, to Paolo, to Giovanni, to all of you. And I am looking forward to meeting you in person here in Sicily as soon as possible.
Sure. Antonio, if you can connect after, you are welcome, absolutely.
It is difficult because I have many activities of the tribunal to complete just this afternoon.
We understand that, absolutely, we understand. Okay, now we have a pause for an hour, and we meet 3:45. And I hope also that we can carry on with our debate about this different aspect about safeguards and so on, the standard of the proof and so on. And after we will have also Paolo Spiezia to talk about the first practice in the application of the regulation. Thank you so much. See you later.
Thank you.
Thank you.
Thank you. See you later.
About this aspect of the safeguards, the guarantees, no? Which have to be in order to apply this regulation, for example, first of all, the standard of the proof. Also, another aspect, the application of the principle of legality means also the principle of no retroactivity, for example, because if we speak about the guarantee of the criminal matter, we have to speak also not only about legality. It is not enough that a law that there is a law to give the rule for the application of a confiscation, but it's also important the principle of no retroactivity. That is a specific principle of a criminal law. In Italy, for example, the principle of no retroactivity is not applied to extended confiscation, even if extended confiscation is applied after the conviction, or to the confiscation, preventive confiscation, because confiscation is considered a preventive measure, a measure of security, is not a criminal sanction, so the principle of no retroactivity is not applied. But if we want to apply the guarantee of the criminal matter, we have to apply also this principle. In Germany, the solution in many cases has been different, no? In many cases, even if the Constitutional Court has affirmed that, for example, adviser-ter Verfall, extended confiscation, is a Maßnahme, is not a Strafe, but the German law has provided with the principle of no retroactivity. So, but before to ask everybody which the opinion about this other subject, the guarantee and the position of the European Court of Human Rights in relation to the form of extended confiscation, non-conviction extended confiscation, after the talk of Balsamo and Albuquerque, I would like, it is my pleasure, to introduce Filippo Spiezia, with our head of the Italian desktop in Eurojust, with also an expert in also in this sector and in general in the topic of the judicial cooperation. Filippo is a judge, is a prosecutor from 1991, also so-called anti-mafia, has been also substitute anti-mafia prosecutor from 2003, member of the Consiglio Superiore della Magistratura, Comitato Scientific Committee of the superior organ of the jurisdiction in Italy, and of the nation. He was also a member of a National Anti-Mafia Direction and Anti-Terrorism. So, yeah, and also he has, for example, obtained a special Premium Falcone and Borsellino for the book The Traffic and the Employment of the Human Trafficking. But he has also many publications in the sector of judicial cooperation. So today he can give us the idea of the first practice in the application of the regulation and the issue connected to the first application of the regulation. In particular, analyzing this aspect, which are the topic of today, what means proceeding in criminal matter, which are the safeguards in order to apply this regulation. Okay, Filippo, I give you the floor. Thank you so much for your participation in our workshop and for your participation in the project as a member of the advisory board. Please.
Thank you, Professoressa Maugeri. Thank you, Anna. Do you hear me? Anna,
Yes,
do you hear
yes,
me?
yes, yes, yes.
Okay, good afternoon to you and to all the professors, the colleagues and the friends who are connected. First of all, my apologies if I managed to join you to this very interesting workshop only now. But as Francisco Jimenez is very well aware, on Tuesday we have a college meeting at Eurojust, and during this time, the college meeting lasts quite a long time due to the need to discuss several items in the agenda. So I beg your pardon if probably I'm saying also some words or concept consideration that you have already expressed during the workshop so far. I would like to also thank you, Anna, for your kind introduction in relation to my person, my professional career. When I hear that I have done all these things as it might happen, I get persuaded that I'm getting older, because only when you are older, quite old, you can count, let's say, some achievements. But in short, I can say that I prefer to be presented only in this way. I'm an enthusiastic of my work, judicial cooperation and coordination at Eurojust, where I'm covering the position national member. That's it. And in this position, I would like to share some considerations, thoughts, and views with you in relation to this very interesting topic that you have chosen. I would like to start that from some data. Just in view of this meeting, I've requested to my analysts to calculate the number of cases registered at Eurojust, and as far as the Italian desk is concerned, in relation to freezing and confiscation from 2016 to December 2022. And we count more than 200 cases, 223 operational cases. Of course, not all the cases we have worked on at the Eurojust Italian desk concern the implementation application regulation of December 1805. Some, let's say, half this year belongs to the old regime, but in total, I think that is really a considerable amount of operational cases. When I refer to cases, I'm referring to correspondent proceeding in Italy, criminal proceeding or proceeding aimed to the freezing and confiscation adopted by the Italian authorities, for which they have requested support of Eurojust. For doing what? For coordinating investigations. It's quite recurrent, the practice that we need to ensure simultaneous execution abroad of different seizure and confiscation orders. It can happen also that they are coupled with a personal pretrial measure like arrest warrant, European arrest warrant. So we need to coordinate the final phase of the execution. But colleagues come to us also for the need to ensure to overcome some judicial cooperation problems, especially in this field of asset recovery, confiscation of criminal assets. This is really in an area which remain very difficult from a legal point of view. From the practical point of view, it remains still very challenging. And the EU legislator is aware of this, because you are perfectly aware that in the preparation, in the considerando of the regulation of 2018, but also in other instruments, the recurrent mantra from the EU legislator is that only a limited percentage of the proceeds of crime are seized and recovered by the competent national authorities. So the amount of illicit richness and procedural crime in the hands of criminals and especially organized crime still amount to almost the totality of the procedural crime. This is very dramatic if we consider that still this problem remains after long years of discussion. Still is a big problem for practitioners and from national authorities. Although we have to say that we have quite numerous judicial cooperation instruments, international legal treaties at EU level, at international level. Probably this is the area where we can count more treaties than international, or let's say legal instruments than the other areas. But this is a sign for me and also for my colleagues of the perduring problems, persisting problems in this specific area. But having said that, it goes without saying that thanks to all these operational cases and also other national desks, other national members have similar percentage amount of cases like Germany, France, Spain, Portugal, colleagues from Romania. we have learned a lot. We have formed quite relevant expertise or experience in this specific field. And let's say the main outputs of this expertise from Eurojust's side have also been shared at the national level with the practitioners, with the relevant national authorities through dedicated reports. Let me recall that over the time, Eurojust has been able to prepare, to gather the experience and to prepare dedicated reports which cover also the topics under your attention and consideration. Just this morning, to recall that we have approved the last report in the field of missing trade intra-community fraud, which the so-called MITIC fraud on intangible goods and services, which have a specific chapter on asset recovery. And it's nice also to recall the title of this paragraph 4, which says the battle against time and complexity. This, I think, give the direction of the difficulties we are facing at EU level in relation to this specific area. The battle, I like to repeat, the battle against time and the complexity. But this is not only the only report that I would like to draw to your attention. Specifically, it's worth mentioning the report of 2019 on Eurojust casework in asset recovery. We have also the version at a glance. Then we have approved last year the report, Eurojust report on money laundering. All these reports are available on our website. I'm just referring to this because I think that there is an amount of knowledge and expertise in such reports which is worth to flag to our colleagues, to researchers, academics, and practitioners. But again, in relation to the title which I just read of the report approved today, the battle against time and complexity, I got an immediately connection to one of the message or the key speech of Giovanni Falcone in 1988. It's worth recalling this, how much time has passed and how the situation remained almost unchanged. In front of the Anti-Mafia Commission, and in order to explain the links between the assassination of Mattarella, the president of Sicilian region, and the mafia, Falcone said, the money has the heart of a rabbit, but the legs of the hare, della lepre, we say in Italian. Il denaro ha il cuore di coniglio e le gambe della lepre. So Falcone concluded his speech by saying, it will not through repetitive mechanics, bureaucratic bank inquiries, very generalistic or generalized economic investigations to get information about the possession of movable and movable goods possessed by the mafia type organization. We are confronted with an organized crime which has enormously grow in terms of potential economic capacities, and the crucial point against the battle against mafia and other organized crime is the possibility to deprive organized crime of the proceeds of a crime. This is the key message of the lesson learned by Giovanni Falcone, and this remains, in my humble opinion, the main difficulties for practitioners. Although we can now count on the support, on the possibility to activate new judicial cooperation instruments based on the principle of mutual recognition. The need to reflect and to use in a better way, or in the best way, in possible way, the experience and all the lesson learned at Eurojust as a trigger an initiative which I took in my capacity of Italian national member at Eurojust in cooperation with Italia Guardia di Finanza, Guard of Finance. We have this specialized force in Italy, Guardia di Finanza, which is the economic and financial police force in Italy, devoted especially to this asset tracing asset or criminal assets and recovery of them. What we did is to sign a protocol, which I take the liberty to also to flag to your attention. This is a protocol which is considered in the context of Eurojust a very good practice, because we decide to start a bilateral cooperation by analyzing the so-called cold cases coordinated by Eurojust in relation to these specific activities, asset recovery and criminal and confiscation of criminal assets. And the results, the outcome of this protocol was the first release of a white paper adopted in 2022, which I would like to share with you all, because we have a double version, Italian version and English version of this result, where a specific chapter is devoted to the issue of the not conviction-based confiscation. We have identified some specific cases already close, where we managed also to achieve some results, and we elaborated on these specific cases in order to try to find possible lessons useful for our colleagues at home, also for the police, but also for other EU colleagues. The specific chapter concerning the confiscation based on the not conviction decision. I will not go, of course, through the whole, let's say, analysis that we carried out, but one main conclusion of this analysis is that we still are in a situation where there is, let's say, a dishomogeneous legal treatment of this type of confiscation in EU member states. We know that concerning the types of non-conviction based confiscation currently provided at European level, we have 4 models of this type of confiscation. We have the classic non-conviction based confiscation, which apply when the conviction is not possible because of the death, because the offender has fled, or because the court consider him unfit, and or because the proceeding can stop or should stop for the immunity. This is the classical type of non-conviction based confiscation. We have the second one, the hypothesis where the extended confiscation, which allow the issuance of an order or against assets that are not related to the offense for which the offender has been convicted. We have the third model, a case of action rem, where proceedings are brought not against the person but against the property in order to confiscate the one obtained through illegal conduct. And we have the fourth one, which in my opinion is the model which we recognize also, the Italian misure di prevenzione, the confiscation of unexplained wealth that includes property acquired by a person with sources of income which cannot be explained, which are disproportionate to legal income, and where is a need, where is anyway a link to the criminal behavior of the person. And in respect to these 4 models, the situation, I think that you have already analyzed this, is quite well explained in the Council of Europe document, in a special document called Analysis of Non-Conviction-Based Confiscation Measure in the European Union of 2019. Although the documents dates back to 2019, in my opinion, still reflect more or less the current situation, where 25 member states have adopted the classical non-conviction based confiscation model. Only 13 member states have a procedure for a sort of action in rem, and in which we include also the Italian experience. In light of above, the situation in terms of possibility to apply successfully the judicial orders containing confiscation or freezing order, which are not based on a conviction, remain still a challenge. I cannot provide you at this point in time precise figures, because we are completing the analysis also in view of the annual report for 2022. So I will be pleased also to provide you with the follow-up figures in light of the analysis of the cases that we have dealt in 2022. But in general terms, I can tell you that 50% of the cases that we have dealt at Eurojust in terms of Italian desk, so I'm speaking in my position of Italian national member, did reach the aim to seize and confiscate criminal assets. So also in light of the new regulation, the regulation of 2018 on the mutual recognition of freezing order and confiscation orders, the results are not brilliant. The experience shows that a lot of difficulties remains. To be honest, this is not only depending on the variety and the divergences of the national legislation in recognition of these type of measures. And of course, I'm referring to, just to be clear, to the implementation of the preventive seizure and confiscation, like in terms of misure di prevenzione, preventive measure adopted in the Italian system, for which Italian colleagues record to Eurojust in order to seek support and assistance for the implementation. But we need to be honest, not only the negative results achieved in this field are depending on the legal framework, or difficulties of legal framework, or limitations in the legal framework. Some of them are depending also on how the judicial orders, the certificate are filled in, are prepared by our colleagues. This is depending also on the national jurisprudence, which allow to some extent the possibility to incorporate the motivation which grounds the reasons for the confiscation by making reference to another judicial order, the so-called motivazione per relationem. And it's really difficult for foreign authorities when they are confronted with the request to implement an Italian certificate, where the motivations refers to the motivation of a pretrial judicial order, which in turn refer to another document to implement, first of all, to understand the criminal reasons behind this wealth, this unexplained wealth, and then to ensure proper implementation. And at this point starts the role of Eurojust. So, in other words, we need to intervene in order to re-explain the procedure. We need to re-explain how it has been possible to consider some assets, criminal assets, in terms of direct or indirect procedure of crime, or unexplained wealthy, which justify possible freezing decision or confiscation order. So there is, that's why this is not only, let's say, the only practical problem that we have encountered in trying to help our colleagues in the implementation of these decisions. We have a numerous of the issues related to practical way to fill in the certificate, and they are also related to the internal system. In order to address in a general way these practical problems, we have elaborated some fact sheets. We presented also this fact sheet in Bari when we celebrated the 20 years of the anniversary of Eurojust. We had also the honor and the privilege to have Anna Maugeri with us, and Anna is aware of this initiative and the fact sheets. We have also managed to have the English version of this fact sheet. Another practical challenge that I would like to mention, which is relevant because we are talking about practical implementation of this decision, are related to the let's say the lack of specificity about the assets to be seized and to be confiscated. It is important that the issuing of such decision are proceed in advance by a proper identification of assets, by making a proper use of financial investigation unit and by asset recovery offices. In other words, it's really difficult that foreign authorities will be able to implement, to execute such confiscation order without a proper specification, which is also required by the certificate to be filled in. But in addition to this practical problem, to be honest, I see that although the intention of a new legislator in preparing and adopting the regulation 2008 was to broaden and to extend the scope of this instrument based on the principle of mutual recognition, also to in order to include other type of confiscations which are not based on conviction, criminal convictions, and this is quite clear according to the recital 13 of the regulation. Probably the specific provisions, the articulation of the single provisions have not succeeded in pursuing this specific aim. What I want to say that yes, it's true that this was also, especially thanks also to the Italian delegation during the negotiation, to broaden the scope of application of the regulation that should apply to all freezing orders and confiscation orders issued within the framework of proceeding criminal matters. And you are well aware of the enlargement of the concept from criminal proceeding to proceeding criminal matters. But having said that, I don't think that the specification according to which proceedings in criminal matter is an autonomous concept of union law interpreted by the Court of Justice of the European Union, it has been, let's say, a specification which helped in order to facilitate the acceptance of these instruments and implementation of judicial order. I try also, let's say, on a personal basis, to find a specific reference to this concept of proceeding criminal matters as autonomous concept elaborated by union law. And I think that here, I didn't find, to be honest, a lot of specific reference in the preparatory work of this regulation. But I think the reference is especially to the jurisprudence of Court of Justice, where the concept of substantial criminal proceeding as elaborated in relation to the topic of bis in idem, in order to make a distinction between the criminal proceeding and other proceedings which, although have a different denomination, are substantially to be considered as a penal. Therefore, the main features of these proceeding criminal matters, I don't know which is your opinion, I reached the conclusion that the main features of the proceeding criminal matters are the patterns, let's say the patterns of the proceeding criminal matters are the following. The fact that the proceeding is foreseen by legislator, by law. There is a proceeding in front of a court, judicial court, a criminal court. There is a level of guarantees for the person involved with possibility also to lodge an appeal. But also, and this is, I think, the most critical point, the final decision should have the feature of a substantial, let's say, penalty or punishment for the person involved in it. Although we can call civil sanction or administrative sanction, but for the gravity, for the seriousness of the legal consequence, these are totally to be considered penal in de facto, criminal de facto. But if this reconstruction is true, dear Anna and dear colleagues, I have some difficulties to apply and to use this legal scheme to, for example, the confiscation orders adopted in the context of preventive measure in Italy or not conviction-based confiscation, because again we fall in the in relation to another important issue, which is the conceptualization of a confiscation. What is the aim of the confiscation at European level? Are we talking about criminal sanction, or are we talking about a different concept? And in this regard, I completely agree with the conclusion of Anna, which she reported in a recent study on the concept of procedural crime in relation to the Italian system, which considers the procedural crime not a criminal sanction as such, but the aim of the confiscation is try to rebalance, to restore the balance against the person who gained illicit procedural crime. So in other words, it's a sort of a reaction from the system to sort of illicit enrichment, what we call in Italian system, in civil law, arricchimento senza giusta causa, enrichment without proper justification. And if this is true, in my opinion, this is true, also in relation to the confiscation for equivalent, although we know that there is a long, quite huge debate also at Italian level about the national confiscation in relation to the confiscation for equivalent, I think that we have some difficulties to apply the reference included in the Article 13, proceedings in criminal matters. Indeed, de facto, the reaction of our colleagues when we knock their doors and we are seeking their support in order to implement such a decision is the following. Filippo, are you sure that we are not talking about administrative sanctions or administrative procedure in relation to your procedure? We don't have a similar procedure in our system. We have different, we have the extended confiscation, we have other type of confiscation, but not this type of confiscation we are talking about. So that's why the results, but again, I'm just summarizing the main the main output of a long discussion and expertise and experience, operational experience with our colleagues. I will turn to you in the future with more details analysis, is that we cannot succeed to implement almost 50 of our the decision adopted by our colleagues, which explain why we are paying a lot of attention to the new proposal on the table of a directive on asset recovery and confiscation. And we consider that the recent changes during the negotiation in relation to Article 16, the confiscation of unexplained wealth, are can be considered in the right direction. Indeed, in the original, in the initial formulation of the Article 16, again we have this confiscation of unexplained wealth linked to criminal proceeding or criminal activities. The concept is probably different. We need to have a system at European level able to touch upon to get all the unexplained wealth, because the wealth can be protected, can be, let's say, can receive a legal protection, legal consideration only if it's justified. This is more acceptable for our constitutional system. For, let's say, the West countries, European countries, is less accepted for East European countries, where they have in their constitution a special reinforced protection of property, also for historical reason, as reaction to the old communist regime. So I think that we need to decide at European level if we want to have a common answer to this question. Do we want to have efficient instruments in order to deprive criminal organization and criminals from procedural crime and any sort of unexplained wealth? I think that we need to answer to this question, because we do not need necessarily only one single instrument in order to, let's say, include under the umbrella of this instrument all the different initiatives and measures existing in the single EU member states. Yesterday, talking with my colleague of the permanent representation in Brussels, I said, I will be satisfied also by knowing that there will be, or there is, at EU level, a specific judicial cooperation instrument which can allow the implementation of administrative measures or civil measures. But the point is that you need to have in place some judicial cooperation instruments, although your measure cannot be considered as a criminal stricto sensu, but the measure to implement as a different nature. The problem arises when the assets are located abroad, when you need a cooperation of the foreign authorities. Then, irrespective of the nature of the measure, you should have in place some specific instruments. You should have judicial cooperation instruments for the implementation of criminal sanctions, for criminal confiscation, but you need to have in place also other judicial cooperation instruments to implement a measure of a different nature. This is a very practical conclusion, I understand, but it is really needed, because I don't understand why, when the EU legislator provided the regulation of 2018, we don't have any sort of, let's say, preparatory paper, non-paper, as you like to describe it, to call them, in order to classify and to have a list of all the measures existing at EU levels in the single member states which fulfill and comply with this requirement of proceeding in criminal matters and not. We still remain depending on the decision of a single judge. So the very paradoxical situation is that even in one single member state, you can have different decisions adopted by different judicial authorities. Like, for example, to be very transparent over with you, we had a similar situation with Romania, but it's not the only one EU member states where we found, we succeeded to implement a measure adopted of this type of confiscation, where other judicial authority of the same member states refused or did not recognize the measure. So this is just a clear confirmation of what is the confusion that still reigns at EU level in relation to this measure. Thank you very much for your attention. Again, I will come back to you with a more thorough, complete analysis when we have concluded all the operational analysis related to 2022.
Thanks so much, dear Filippo, for your analysis of the first practice. There are a lot of important arguments in your presentation. First of all, I would like to stress that the aim of our project is to give a kind of frame of the model of confiscation in the national system of law, which can be included in the scope of the regulation to clarify this first of all. And okay, after I have some question, but first of all, I would like that also the other member of the other participant can present their question, and I give the floor to Anastasio Matteo from Transcrime.
Is Ernesto Savona? We are
Okay.
Transcrime. And Mr. Spezia, thanks for your intervention. I have a key question, I think. I'm sorry I was late to your speech, and you provided us with some data, aggregate data between 2015 and 2022. But I think it's very relevant for our project. We are partner to this project. If it will be possible to get some relevant data on how the regulation works and how it could work in the future. Let me be clear. It will be extremely interesting for us aggregate data first between 2015 and 2020 when the regulation came in force, and after 2020. But more, I think it will be extremely interesting if there will be some data about which country has requested, which country to whom has been implemented, and more details when there was a refusal, if there was a reason, a decision, why. This will be extremely relevant for us to understand what does work and what is not working or what is promising, of course. And I think this will be a treasury of knowledge because the regulation is very young, it's a baby, and probably will become mature in the next 10 or 15 years. And before there will be some changes. And if it will be possible to monitor, I don't know if Eurojust is monitoring this regulation in all the data, and if this data will be available to researchers, it will be a great treasury for us to have this data at our disposal, because we can understand a lot of things, especially between the different flows of country requesting, implementing, a reason for not implementing, all these things. This will be extremely relevant. Are these data available or do they exist in terms of data?
Okay, thank you.
I can answer immediately if Anna agrees.
Yes.
Okay.
Please.
Professor Savona, thank you very much for the question and also for pay attention to my short presentation. Yes, you are right, and I agree with you. This is a treasure for the research, for practitioners, because we can learn a lot. There are two things to be said. First of all, some of these cases are still pending, so are operational cases for which investigation and prosecution is still active. So there is no possibility to disclose information, of course, without the consent of the involved national authorities. We have at Eurojust, and Francisco Jimenez Villareo is well aware of this specific exercise in place, the retaining knowledge exercise, because this is exactly what the legislator in Brussels request to Eurojust to provide input in relation to the functioning of European judicial cooperation instruments. We are proceeding in relation to these cases not in a systematic way. We have the data that you are referring to are here, are in our CMS, case management system. So all the data are available in terms of who is the requesting authority, who is the requested authority, if the judicial order, the confiscation has been reorganized, executed, and if not, for which reasons not. Decision for refusal, recognition, and the execution. All this is in our system, case management system. The problem is that we don't have sufficient manpower for the moment to make a systematic analysis of all the cases. I'm speaking in terms of Eurojust world, so not only in relation to the Italian desk, but all Eurojust agency. Although just this morning we have advocated for next budget 2024 new resources, human resources. We need new staff members in order to comply with all these requests, and in order to especially to conclude the ongoing project. So retaining knowledge is an ongoing project at Eurojust. So as long as we conclude, let's say, the analysis of specific topics, we provide the report, and I will just mention some of them. In relation to the Italian situation, I, of course, try to be ambitious, and I'm just pushing also my colleagues here, because we are preparing the annual report for 2022. And one of the topics that we will address in this report will be specifically the level of implementation of judicial or a confiscation orders, reasons for refusing execution, and also positive cases. So you will read more, let's say, detailed information in relation to the level of success and the problems encountered in the implementation of this decision. In general terms, I see that probably the Academy can help us with the dedicated project, also by deploying resources, because one of the main problems is that we are confronted with really operational tasks which represent the priority for us. After concluding this meeting with you, I have urgent requests to deal with. So we are confronted with a pressing priority, operational priorities. If we would be able to arrange a project with the Academy in which we can count on your support, your resources, I think that this could be an option that could be considered also at Eurojust level. And a project where we should involve, in my opinion, also the EU Commission, because the Commission can advocate similar projects. It's a common interest. It's a common interest to analyze the problems encountering in implementation. Because when I see the level of the negotiation, the discussion of the negotiation, in relation, for example, also to the new proposal for a directive on asset recovery and confiscation, I see that a lot of discussion could be really easily overcome by taking into account the result of the experience, the result of the practice that probably is not known to the EU legislator. So we need to create this connection, stronger connection between practitioners, the world of the practical experience, the world of the Academy, and also the EU legislator. This is just an idea. I don't know if we can have, let's say, also as an output of our common project, something which can achieve this important aim. But in principle, I agree with you. I see only two obstacles to be concrete. One, that some of the cases are still pending, so it will not possible until the case will not be closed to analyze the case. And second, to have, let's say, the dedicated resources to make a systematic research and analysis of all these cases. I hope that I have answered your question.
May I have a second question, an opinion of Mr. Spezia? Anna Maria, may I?
Yes, please.
Mr. Spezia, you are a very good expert in the field, and I have a curiosity or mainly a concern. What do you think about the experience, or better, the non-experience of judges in evaluating the request from another country? In few words, don't you think there will be the need to train judges in a country on this field? Because Anna Maria has given to us the idea of the complexity of the machinery. And I think that a normal judge will not be able to contrast the defense lawyer, that just because we are dealing with money, will be much more expert than the judge in evaluating the proofs. I think the need, my concern is about if this regulation fades, many criminals will make a lot of investment abroad, because according to the numbers, in Italy and many other places, they do thousands of confiscation, and in the end, in the finger of the hand, the regulation. So training judges on this field, it will be possible, or having a court that is dealing with this request at the central level. Because my concern is about the periphery of the judges, the periphery of the courts. Judging is something that they will not be able to understand.
Thank you for this question, because I think that this is really a vital area where an improvement is strongly needed. We can, let's say, make the best arrangements or training or raise the expertise of prosecutors, but if we take out from this system or training activity and the judges, the courts, who in the end has to take the decision, the system cannot be improved a lot. I have a lot of experience in this respect, where colleagues have practical difficulties. I mentioned only a few of them. Practical difficulties in issuing such a decision, because the certificate should be issued by the judicial authority who take the decision on the seizure and confiscation. The prosecutor is only a part of the game, and it's not, let's say, also the most relevant part. And the same happens also in other sector. Just to make a reference to another sector where the problem is exactly the same. we are in a good process to raise the awareness, for example, of the German prosecutors about the modus operandi of mafia type organizations, how mafias infiltrate their economy, their territories. But although all these improvements, and there are really something which is amazing, referring, for example, to our colleagues in Duisburg, then when we are confronted with the quality and the awareness from the courts, from the judges, still remain a big problem, because they are out of this, let's say, also world where we exchange information, we exchange practice. So I think that you touched upon a very important issue. It's a question of training. It's a question of a specialization of the courts. Specialization can be achieved by identifying a court at national level. This could be a solution at the regional level, but this is really, really a big problem. And the example that I brought before concerning the court, the decision adopted by two different judges in the same EU member state, who received the decision from Italian authorities in order to implement this preventive measure, misure di prevenzione, which went into two different directions. It's just the practical confirmation how important is the topic that you have raised. Thank you.
Grazie.
Okay. Other question? Okay. My question. Filippo, it is not clear for me, but in the regulation is quite clear that the concept of proceeding in criminal matter is a very broad concept. It is enough a proceeding with a connection, a link with a crime. So in theory, it is enough that a judicial authority, this is important, deal with something which is connected to a crime. So this means in the praxis, the proceeds in particular, but also the instrument of the crime, in order to be a criminal proceeding, to be included in this concept of proceeding criminal matter, because recital 13, it is an autonomous concept, it is under the jurisdiction of the Court of Justice. What is important is this relation with a crime. It is not possible that is an administrative or civil proceeding, but this means only that it is absolutely administrative or civil when there is no connection with crime. If there is this link with a crime, we can speak of a proceeding in criminal matter in this autonomous concept. And also the concept of judicial authority, a court for criminal offense, we have analyzed today in the morning. Also in the opinion of the Court of Justice, is a very autonomous concept of the union in broaden, which has a broadened meaning independently by the qualification of the member states. It is possible that a court has also other competence, but it is enough that this court deal with something that is connected with crime. So, and also in the working in the work in order to elaborate this regulation, no? There was this debate about also the work of the Italian delegation, the Irish delegation, was to extend this concept of proceeding criminal matter in order to include our confiscation preventive measure. So after this work of the delegation, after we have different also in the press, also by the Ministry of Justice, the Council of 2017, which affirmed in a clear way that the concept of proceeding criminal matter in the regulation is a broadened concept which include also proceeding in order to apply confiscation without conviction. Why, in your experience, your colleagues, the other prosecutor, carry on in this approach, in this critical approach, in the idea that it is not possible to include the Italian preventive confiscation or other form of non-conviction-based confiscation in the scope of the regulation. Cioè, I can understand that the problem for the prosecutor, for the court, is to understand say, if in that system of law, in this broadened concept of proceeding criminal matter, the member states guarantees the fundamental guarantee of a proceeding in criminal matter. I can understand this, but that there is this approach so skeptic approach against a form of confiscation without conviction after the clear position, in my opinion, the clear position of the regulation and of the European legislator in order to improve the mutual recognition also of this model of confiscation. Also in the explanatory report of the proposal, it was clear that the concept of confiscation was a broadened concept, no? Confiscation of a value, direct confiscation, confiscation against third parties, confiscation, extended confiscation after conviction, and non-conviction based confiscation included the concept of actio in rem. Please.
Dear Anna, thank you for the question. I would like to answer your question with another question, if you allow me, with all the respect. Why, the question is the following. Why in the Article 2 of the regulation concerning the definitions, we do not have a definition of the concept of proceeding in criminal matters?
Yes, this would be better to give this definition, but yeah.
Article in the recital 13, but as far as definitions are considered, we do not have definitions in the legal text about what is the proceeding criminal matter. I can answer from my experience by saying that we do not have definitions because the recital 13 was simply a compromise during the negotiation that was introduced especially in order to give an answer to the Italian delegation for the need to enlarge the scope of these instruments. But when we have compromise solution without sufficient clarity, the results are the results that we see on the table. So to be even more frank with you, personally speaking, I don't think that this is a clear concept which can justify the adoption in new member states of initiatives, of proceedings in order to implement requests coming from other member states. Because when we talk about proceedings which affect the right of properties, the economic wealth we need to have clear procedures, clear principles, clear definitions. We need to respond to what the Court of Human Rights says, il principio della prevedibilità, the principle of foreseeable. Any decision should be clearly stated and stipulated in the legal text. This is, in my humble opinion, not the case, although, of course, as Italian national member, I try to persuade my colleagues abroad about the fact that all these procedures fall within the scope of the regulation. But when they pose to me the question, okay, Filippo, you are saying that all these assets, let's say the shares of a company to be confiscated abroad have been adopted in the framework of a proceeding adopted by a court in Italy, where all the guarantees have been adopted. But are we talking about proceedings related to a crime? I said, well, the person in question was acquitted for a mafia type association, but although this acquittal, he possessed a lot of assets for which he did not give an explanation. So the court is persuaded that all these assets can belong more to criminal activity rather than to licit, to legal activities. Okay, and so they turned me with another question. So are you talking about proceeding in relation to other crimes different from which the main, let's say, conviction occurred? So a person convicted, for example, for homicide, for mafia association, and then you have also a lot of assets which can be linked to other criminal activity. But I say no, because this is the model of the extended confiscation, where you have at least one confiscation for a specific crime. So, in the end, the question arises, allora, you are referring to administrative procedure. You are referring to a civil forfeiture. No, I'm referring to this one. So you have some peculiarity in your system, which, unless you have a specific provision in the definitions of what is proceeding in criminal matters clearly stipulated in the regulation, we encounter problems in implementation. Just to give to you a clue of these difficulties, in the same member state, in the process to find, let's say, the proper answer for the recognition of a judicial decision or a certificate, there were 3 decisions from the court to the prosecutor abroad from a foreign country. The case concerning Romania. First, the court decided the competence was of the prosecutor. The prosecutor then decided the competence for the same judicial measure was of the court. So this is a clear demonstration that our partners do not understand what is the procedure we are talking about for which we are requesting judicial assistance. So I think that although the good intention of the new legislator, the ambiguity remain in the legal text, and which does not pay. This ambiguity is not facilitating the needs of the practice. The judges would like to have clarity what type of procedure we are confronted with, what are our obligations, what are the legal requirements. And I'm just concluding with another question to your question, final question. Why we did have any sort of preparatory document or internal document or no paper, as I said before, where the competent legal offices of the council, of the commission, listed all the procedure in new member states by saying, at least in terms of indications, final decision will belong, of course, to the courts, but at least according to the preliminary analysis, we can say that in Austria we have this which can belong to, in Bulgaria we have this procedure which can belong to. We don't have any sort of similar analysis. This is the indirect confirmation that although the goodwill, we are still in an ambiguous situation. This is the level of my assessment so far. Probably, I hope to change my mind in coming months.
No, I agree with you. So this is also the aim of our project, no? To give this list to understand which are the model of a proceeding criminal matter in order to apply confiscation, which can be included in the regulation. This is sure. And it is sure that is a compromise, no? In the beginning, it was a proceeding, a criminal proceeding, after proceeding criminal matter, this ambiguous concept. And I would like also to stress that the European legislator has to have the brave to declare in a clear way which are the fundamental guarantees that in this kind of proceeding have to be respected in order to apply the regulation. This is sure, and this is also a challenge for our research to try to verify which are these proceedings, which are the fundamental guarantee, which is important that are applied. And in my opinion, it is also important to improve the knowledge in order to improve also the mutual trust. No, the approach of the French Supreme Court in the old case that I have quoted today, Crisafulli case, was an approach, a real concrete approach, no, but with that was based on the mutual trust, no. Okay, we don't have preventive confiscation, but we are sure that confiscation was applied in the respect of the fundamental guarantee, and in any case in France we have other form of confiscation against that kind of crime, like drug trafficking or money laundering. So what is our challenge is try to understand which can be the proceeding that can be included in the regulation, and which are what means what this broaden concept of proceeding criminal matter, which are what kind of proceeding have to be, which are the fundamental guarantee that each member states has to respect.
Anna, allow me a comment on this, if I may.
Yes, please.
Because you mentioned the Crisafulli case, which is well known also to Italian practitioners. But I have to say that if we can account as a positive experience the Crisafulli judgment, this means that we have still a lot of way to do ahead of us, because this was based on a different legal context of the COE Convention. And although, let's say, the progress made in the context of the EU legal framework, probably there are very few positive experiences that can, let's say, demonstrate that we have departed from that experience. And it's true that still now, the most successful operational cases that we can conclude for the implementation of confiscation order are based on the COE Convention instead of the EU legal instruments, COE Convention 1990 or the 2005 Convention on money laundering, rather than the EU legal instruments. Because in that case, we had a very clear explanatory report accompanying the main convention, which was very useful to persuade the French authorities that there were legal grounds to implement the Italian judicial decision. So you see how the clarity of a legal text is essential in order to get positive results from the operational point of view. Sorry for interrupting you.
No. This is sure that this can be also our chance. Try to stimulate by the European legislator an instrument, also a soft law, to clarify what the concept of the regulation. And also in this period, our project can be important also in order to give some impulse for the new directive about the concept. In particular, the challenge of the new directive is this concept of confiscation, non-conviction based confiscation. But Francisco Jimenez Villas maybe has a question for you. Please, Francisco.
Yes, well, it's more than a question. I mean, and I'm sorry to take the floor again. I just want to say hello to my dear colleague Filippo. I fully understand, I fully support, and I fully agree with my colleague on the necessity of having guidance on this particular issue of the, well, how to interpret it, what is the meaning of the concept of proceedings in criminal matters. I had the opportunity to work in one of these Eurojust reports. The report was on the casework of assets recovery, the 2019 report. That report was an excellent document to see what is the practice on focus on assets recovery, but it was before the entry into force of the regulation. Now, the issues that we have on the table are completely different. It's still the same, but different. And this is one of the main topics. That is why I would like to make a reference to one judgment of the Court of Justice of the European Union. I have been working during this webinar because I am at the office, and I don't know if anyone make a reference to it, but I think it's a very relevant judgment. It's the judgment issued in the 19th of March of 2020 in the case Agro in 2001. In this particular case, the Luxembourg Court analyze one freezing order issued by the Anti-Corruption Commission in Bulgaria. And the Anti-Corruption Commission is an administrative body, and the freezing order was based in a in-rem action. Then the case is very, very interesting. And finally, the Luxembourg Court decided that framework decision 2005, 212, does not exclude proceedings, confiscation proceedings that are administrative or civil, like the one opened by this Anti-Corruption Commission. Then this is a very good precedent, taking into account that the recital 13 of the regulation expressly referred to the autonomous concept of union law that should be interpreted by the Court of Justice of the European Union. Then we have to rely on the interpretation of this concept by the European Court of Justice. And we have to also be very, well, we really look carefully what is the evolution of this case law and whether the case law is accepting and including these types of proceedings that are not purely criminals, but are linked to the to offense or to behavior that this could be classified like an offense. In any case, this is not the end of the world, because before the entry into force of the regulation, I remember that for these situations in Spain, we invited judicial authorities to use also instruments that are in the field of civil judicial cooperation, and they are also part of the union law. But sometimes it's good to know, and it's good to remind that we have other instruments that are very useful for these cases. Thank you so much. I'm very happy to see you, Filippo. Hope to see you in person soon. Bye.
Francisco, the case is Agro. Okay.
Yes, it's Agro, yeah.
Agro. Okay. Can maybe you write some reference about this case, which is the number of the case, if you know, in order to find quickly.
Yes, the case is C234/2018.
Excuse me, I might confirm what Francisco said. So this is the exact number of the case, C234 from 2018.
Okay. Maybe I have, yes. Okay, so also for, but is about the regulation. No.
Is the judgment analyze an article of the 2014 directive, and also another one from mainly the main legal instrument that is analyzed in this judgment is the framework decision 2005/212.
Yes. Okay, yes, I know. Okay, yeah, it's clear. Yes, and yes, the idea. In this case, the court said that it is not important that it is not expressly included in the framework decision, because the member states can apply also other instruments, and the judicial cooperation is possible when okay, exactly. Yes, I know. The approach is yes, is this, no? This approach to include in some way. But this is always the problem, no? Until now, the European legislator has added this approach. Okay, for example, in terms of harmonization, you have to have this model of confiscation, but you can adopt also more extended power of confiscation. But in this case, the judicial cooperation is not binding, is not mandatory. No, now, but with the regulation is binding the application of the regulation. So now it is important not only to establish which are the form of confiscation, this extend the power of confiscation, but also which are the fundamental guarantees that have to be respected in order to avoid this problem. Okay, I can't accept because it is not. So it is true what Filippo said, that it is important also for criminal matter, the foreseeability, to know which are these instruments, to know which are the fundamental guarantee beyond the qualification in the member states. Are there other questions for Dr. Spriezia about this first praxis? Okay, if we don't have other question, if you agree and you are not too tired, I would like to have another round of interview, also in order to know your opinion, the opinion of the member states, or a partner of our project, that the most of the partners are also expert, practical, prosecutor, judge, which is your opinion about the possibility to include in the guarantees, the safeguards that which are quoted in the recital 18 of the regulation, also the criminal safeguards in stricto sensu. I mean the principle of non-retroactivity. I mean which have to be the standard of the proof. because this is also an aspect that is hybrid, not clear, because also in the directive, no, the standard of the proof for the extended confiscation is the a kind of reinforced the civil standard, but in the recital 18 of the regulation, it is affirmed that this proceeding, also if they aren't proceeding a criminal proceeding, but they have to respect the safeguards of the criminal matter. This is what means. It is enough a lower standard of the proof, or as Dr. Balsamo said, it is possible to apply the presumption of innocence as a rule of judgment. So this means higher standard of the proof, no? In the decision, in the framework decision 212 of 2005, it was clear, no? The standard of the proof was the criminal standard of the proof. The judge, the court is fully convinced, no? The criminal standard of the proof. Now it is enough that the court is satisfied that it is substantially more probable that the proceedings have a criminal origin. So what is our direction as a group of research? It is enough a lower standard of the proof, or in order to apply this model of confiscation against property. And the property is also recognized in the European Convention on Human Rights, in the Article 1 of the first protocol. Also in the explanatory report of the Convention, European Convention, is affirmed that the right of property is a right that is connected to the freedom of the personal freedom and the freedom for the family, because it is an instrument, no, to of expression of the freedom. It is so we have to establish, we have to suggest which have to be the standard of the proof. In my opinion, but this is my personal opinion, also of other authors, also in the common law system, for example, Colin King, that is another member of our advisory board, in relation to civil recovery in the United Kingdom system of law, or civil forfeiture in the American system of law, the idea is that, okay, it is possible to apply confiscation without conviction, but at least it is necessary that the court is convinced, is fully convinced, no, that that property has an illegal origin. And so it is, we have also other, okay, other guarantee. For example, is it possible to apply restrictive punishment, restrictive measure of the freedom if it is not possible to apply the confiscation? It is possible in the United Kingdom. In my opinion, this is not have not to be possible. Okay, I would like to have our opinion in particular about the standard of the proof and the no retroactivity principle that in many cases are not applied in this kind of proceeding in criminal matter in order to apply extended model of confiscation. Maybe we can start. Filippo, first of all, I would like to ask Filippo Spiezia, which is your opinion?
Anna, I think that this is a question whose answer is strictly related to the nature of the proceeding we are talking about. If we say that this proceeding in criminal matters, although it's not a criminal proceeding, I think that when we talk about the level of guarantees that should be satisfied by the court, it's always to keep a high standard, unless we are talking about a procedure of a different nature. That's why I see a link with the nature of the procedure. If we are talking about administrative or civil procedure, you can have a even lower standard, and the courts abroad can be satisfied by a lower standard of proof if we are talking about a standard of proof, because you are talking in we have to take in mind the clear lessons and the guidance from the Court of Human Rights and the Court of Justice to avoid that the simple, let's say, changes in the formal qualification can affect the level of guarantees. We need to have a look to the substance of the proceedings. I like how in Italian is recalled this phenomena. We need to avoid the so-called truffa dell'etichetta, the fraud of the labels, if you can say. Therefore, if we are talking about the criminal proceeding, criminal matter, I don't think that we change a lot in terms of we should change a lot in terms of threshold of the evidence supported the decision. I like to recall the experience that we are having in a matter which is always related to recovery, confiscation, and recovery of goods, which is the area of the cultural goods. Cultural goods. You know that Italy has a special cultural heritage and patrimony, and we have specialized forces like the Nucleo Investigativo Carabinieri for the recovery of cultural heritage. And over the years, especially during the last couple of years, we have enriched our expertise in this specific area, working hand in hand with the Carabinieri and also with the Minister for the Ministero per la Cultura, Italian Minister for the Culture. That we have realized that sometimes what we cannot achieve through the implementation of regulation of 2018 through the criminal proceeding, confiscation adopted as a consequence of a criminal proceeding can be reached by administrative proceeding, which is ruled by another framework decision of 2004, and vice versa. Sometimes information and evidence, especially concerning the situation of bona fide of third parties, are collected in the context of criminal proceeding. They are not enough for reaching the aim of the criminal proceeding in terms of confiscation or seizure, but they can be enough for the administrative procedure. Then, as a result, and I think this is really a very interesting and good practice, the Minister of Culture decided to include the Eurojust Italian desk in the Comitato Tecnico, the interinstitutional committee at the level of Minister of Culture. So we attended regularly this session of the committee, and I want to mention this just because this is the explanation and the confirmation that sometimes it's useless to follow the criminal proceeding. Sometimes it can be more constructive and practical and useful to have this double path, depending on the circumstances of the case, depending on the level of the guarantees or threshold that you have in your hands. Sometimes it can be more practical and constructive to follow the criminal proceeding in a matter. In other situations, you can follow administrative procedure. The important thing is that you have also the administrative procedure for these cross-border cases. You always should have some measure, some procedure at EU level, which allow the company and the national authorities to follow the proper procedure, that could be criminal or civil or administrative. But as far as criminal procedure is concerned, my opinion is that we should keep in a quite high level of threshold in terms of evidence in order to justify the effect of impossession and the acquisition of the assets It's true that the principle should be that any assets should be based on a proper justification from the owner, but it's also true that if the state, if a national authority would like to get the acquisition, the possession of these assets, and to reverse, to change the property, you need to have a high standard level of evidence in order to justify this acquisition. This is my view.
Thank you so much, Filippo. Now maybe we can start with João Conde Correia. Would you like to give your opinion, please?
Let me put my camera on. To begin with, I think, first of all, like Philippe Spezia said, it depends on the nature, the true nature of the confiscation mechanism that is in place. If it is a penalty, is one thing. If it is not a penalty, is another thing. Here in Portugal, we can have both. So we have to bear in mind that in one case we should apply all the guarantees of the criminal proceedings. In the other case, we don't need all these guarantees. But in the big majority of cases, it is not considered a penalty. We have also to bear in mind that is a new issue, and all the jurisprudence and all the doctrine is working very hard on the issue. And I think in the future we will have more consistent doctrine and more consistent jurisprudence. But the line, for me, is the line that divides between a criminal issue and a non-criminal issue. And for me, and for the most majority of the people that is writing about that in Portugal, the infamant, related to the information related with the confiscation is not enough to say that it is a penalty. In fact, we have the same issue related with the civil confiscation of victims. We can do that on the criminal proceedings, and we can do that outside the criminal proceedings. Nobody says that it is a penalty if someone is convicted in a civil claim because he committed a crime against a person. If it is done in the civil context, nobody says that this is a penalty. So the same happens with confiscation. If it is not a penalty, because if I have to confiscate the money that someone stole from me, this is not a penalty. So in this case, if it is only that, because sometimes it's not only that, but if it is only that, it is not a penalty. So from my point of view, is only my point of view, we don't have to apply all the criminal guarantees.
Okay, thank you so much. Arnaud de Bless, France. Okay, the name is Arnaud de Blesson.
Yes. Yes, so a bit like Mr. Correa, I share his point of view. Just to say also that in our national legislation, we have there's the possibility for, let me just have the article. So we have the possibility for the person that has been convicted to make an appeal against the decision that has applied the freezing order or the forfeiture order pronounced by a European judicial authority in the framework of mutual legal assistance. So just to precise this modality also, that is guaranteed by the French national law. But apart from that, I agree with the point of view of Mr. Correa from Portugal.
Okay, thanks so much. Lituania, Jurate Radisauskiene. Is with us? Okay, maybe no more. Jan-Elise de Boer.
Yeah, I would like to give the floor to my colleague, Robert van der Ende. He would like to say something about this.
Yeah, because the situation in the Netherlands is quite complex. We have two confiscation procedures in criminal law. We have the object confiscation in the criminal case procedure. And next to that, we have a value confiscation procedure. And for value confiscation, we don't need a direct link or an indirect link between the item and the criminal offense. So when somebody's bought a house in 2000, we committed the crimes in 2020, we still can confiscate his house in this value confiscation procedure. Next to that, as Jan-Elise already mentioned, there is a consent bill for non-conviction-based confiscation, and it looks like that there in this procedure a person of interest has the same safeguards as in the criminal procedure. I think that's the most important for now. It's quite complex, but what I also can say to everybody is that when you have a difficult case, it's always important to contact the other party to discuss what the problems will be when you go to a court to have authorization to freeze or seize items. Because in the Netherlands, we know our system best, but you know in your country what the system is. And maybe with just discussing, we can make or receive a freezing order that our judge will understand as well. And he's the one who makes the decisions. When he doesn't understand it, because we delivered something that he doesn't understand, it's not only to blame to him, we have to blame ourselves as well, I think. Jan-Elise, you want to add something to this?
Sorry. Yes, I think it's the basic principle of how we would cooperate needs to be the willingness to help each other, to confiscate and freeze objects, and then get together in the dialogue of how can we achieve this. So what is possible in your country? What is the system in my country? How should I write my request to you so that you can help me enforce my request? And not think about the problems, but try to think in solutions, how we can make the cooperation between us work as best as possible within the systems we have. The regulation does not say that we need to refuse requests in certain circumstances. It only gives the opportunity to, in certain circumstances, refuse. But even if it's possible to refuse, it also gives the possibility to be willing to recognize and enforce anyway. So the most important part of cooperation within a European regulation is the willingness to help each other and to enforce each other's decisions.
Yes, sure. But this means also that we have to improve this mutual trust, and mutual trust demands also knowledge, no, over our
yes,
system.
and I do also agree with Filippo from Eurojust that we need clear legal explanations, because the concept of criminal matters, I do agree, is not very clear. And the case law we just referred to in relation to the Bulgarian non-conviction based, it gives an explanation in relation to the framework decision from 2005 to 12 and the regulation of 2014-42 in relation to the definition of confiscation, which is the same definition of confiscation in the regulation. So it's still confusing. Even though the regulation clearly states and gives us the indication that Europe wants us to go beyond what we've done before to cooperate on the basis for non-conviction based confiscation, still it's not clear enough whether non-conviction based procedures outside of criminal proceedings with the safeguards of criminal proceedings are linked, closely enough linked to that criminal offense to fall within the definition of confiscation orders. So I totally agree that for the new regulation that is still being negotiated, it would be very helpful if there would be more clear definition and explanation of these concepts.
Sure. Thank you so much. Okay, from Germany, Egger or Professor Egger or Anna Sakellaraki? Please, Anna.
Yeah, hi to everybody. If Professor Heger is not here, then I'm not sure. I could say something about the German model. The thing is that we have in Article 437 from the Criminal Procedural Code exactly such a thing like I think what Professor Mauzeri is saying, like this standard civilistico rinforzato. So it's something like in between criminal and civil standard of proof, and this could be also like taken as idea from the reform of 2017, that the German legislator was not so sure about what kind of like standard of proof would apply in these cases. So we somehow like the opinion in Germany is like that it's something in between. So not criminal, not civil, but something exactly in between. So in this case of presumption of innocence. And the last point is that I have to search about it, but it was the last decision from the Constitutional Court in Germany, and the principle of non-retroactivity, is not finding application in the this non-conviction-based confiscation model, the German one. So the principle of is excluded because the idea is that it's like the legal nature is not a penalty, but it's like a civil measure, or like this not civil, like a restitutive measure. So to go back in the status quo that it was before, like wiederherstellende Maßnahme, and this is the idea that it's not applying. It's making an exception. It is not applying this full spectrum of the criminal safeguards. And the principle of non-retroactivity was ruled out.
This is interesting because in the past, when in German system of law was adopted in 1992, the extended confiscation, which was considered a measure, not a strafe, a Maßnahme, in the opinion of the Constitutional Court, but the law was clear, the principle of legality and the non-retroactivity has to be applied. Now, also in the German system of law, the approach is more direct on the effectiveness, instead of the guarantees. But this is real interesting. Also, this new approach of the German legislator.
Yes, we'll include it in the report. I think it was like 316 of like the Einführung in EGS, TGB. But we will include it in the report. Thank you so much for the feedback today.
Thank you. Now Calinescu from Romania. Cornel Virgilio Calinescu, please, would you like your opinion? Would you like to give your opinion? It's not more with us, maybe? Okay. And from Bulgarian or Vanya? Yes.
Yeah. Thank you for the floor. I'm not sure where to start with because a lot of items have been touched today, but I would like to be very brief. As a practitioner, I'm of course more familiar with more convenient with the criminal procedure. Of course, in this procedure should be applied the safeguards related to that procedure. And the problem is when we are talking about proceedings related, proceedings in criminal matters, so such kind of proceedings which are linked to a crime, but we all are not sure what kind of link is that. We could not specify it because, as we heard today, there is but there is need to be some kind of strict definition of that kind of proceedings. So in criminal proceedings, it's clear. In the other type, which in Bulgaria are dealt mainly by that administrative body which was mentioned today, the Commission, the safeguards should be and are applied to that extent which is possible in that kind of proceeding, because of course the court, which has the leading court in that leading role in that procedure, always keeps the rights of the citizens and the human rights which could be infringed in that proceeding to the extent which is possible. So this is the brief opinion that I could present to you.
Thank you so much. So maybe Dr. Michele Fini from the Italian Ministry of Justice, if he is with us, or from Spain. No, Mr. Fini.
No,
Okay, Michele, yes.
Thanks for the floor. Let me first of all thank Filippo for the clear, accurate, and thorough presentation he gave us, dealing with both theoretical and practical issues we have to tackle while implementing the regulation. As he stressed out, it's not really a simple situation, it's a complex situation. I don't think a single definition can solve all the issues coming up. It's not a situation which can be solved by definitions. We have got in the regulation a concept, which is the concept of criminal proceedings, and this is actually an indication when it is compared with the previous wording, which have to be used, the criminal proceedings. But it's not enough. As we've been saying, as Filippo said, maybe a list would help out, but it seems it's not the case so far. So within that concept, the concept of criminal proceedings, we have to deal with different confiscation measures and systems throughout all the member states. We have got non-conviction-based confiscation carried out within civil proceedings, within administrative proceedings. We have got, as we've been saying initially, 4 different kind of no conviction-based confiscations. So all these issues couldn't be solved by trying to throw out a kind of definition. As we said, maybe a list would help out. As it's not the case at the moment, maybe we should try to define the boundaries within the different measures throughout all the member states would be deemed as covered by the regulation, by trying to set out the principles according to which the actual measure has to be deemed as covered by the regulation. So it can be either the principle of the presumption of innocence, the safeguards, both the substantive and procedural safeguards typical in the criminal law. As for my personal opinion, I think we have to consider it's anyway a kind of accountability, an accountability which maybe it's in half the way through the civil accountability and the pure criminal accountability. We are still talking about a crime, not the crime which is going to be judged like the ordinary criminal accountability deals with it. But it's something different, still connected to a crime with additional elements. And so we have to take into account this different situation while trying to define those principles which could help us find the measures which have to be covered by the regulation. It's not that simple. I think that trying to define these principles is up to either the case law, the political level. Has to be stressed out that is that guidelines, as also Filippo stressed out, would be very useful. These guidelines could be carried out at the central authority level, at the Eurojust level, at Commission level. Anyway, something which can be both not too rigid, but also enough clear to make the different practitioners able to know in advance what they could expect from an actual situation, and so an actual judgment to be carried out by the judicial authorities involved. Thank you for your attention.
Thanks so much. Francisco from Spain.
Yes, if I may add, in relation to this particular issue, what are the rights to be considered? Well, in principle, I have two general comments. First, we are dealing with the right of property. Then I understand the reasoning about the stigmatization or that could be as an impact in the person who the third persons mainly who are affected by these measures. But the right of property is not a fundamental right. It's a right that is in a lower level, at least in the Spanish Constitution. And in any case, you have the possibility to be compensated after the proceeding in a final decision. And the other important aspect to be considered is that we are dealing, in the regulation at least, with the application of the mutual recognition principle. Then, for the executing authority is, well, we just open a sort of instrumental file. We are not revising the merits of the case. Then the approach should be limited.
Yes.
And that is also very important because if we have a look at the grounds for refusal or non-execution grounds for refusal, in the regulation, we have two main articles, and I have made a reference before, Article 8 and Article 19. These articles also, there is a possibility to refuse the execution of a certificate of freezing or confiscation certificate when there is a risk for the fundamental rights, a risk of infringement. But it's really focused on, in particular, rights or to an effective legal remedy, the right to a fair trial, and the right to of defense. And I think it's very important to distinguish between rights. I think these three main rights are the core rights, the rights that really are at a risk, to be considered mainly. Of course, the rest of the fundamental rights are there, but for the executing authority, it's very difficult to assess whether presumption of innocence is involved, or whether any other, the standard of proof, the reverse of the standard of proof, etc. Because these are principal rights to be considered by the issuing authority. That is why I also made a reference to the validation authorities, because it's very important for the mutual trust and for the efficiency, but also for the sake of mutual recognition itself, to have also the proper approach when we deal with these issues. It's not the same being a issuing authority or an executing authority. The issuing authority is dealing with the main proceedings, criminal proceedings or not, but the main proceedings in any case. And there you have a full exercise, or the possibility to fully exercise the right to an effective legal remedy, because the effective legal remedy cannot be filed before the executing authority, and that is obvious. Then these are my comments so far, because I think it's important to have also the right approach when you also make considerations about the procedural rights and how to apply them properly. Thank you, Ana Maria.
Thank you so much, Francisco. Also, it is very important that we have, in any case, to analyze the regulation. In the regulation, it is clear that it is not more a ground for refusal, the kind of confiscation. No, before there was also this. Now it's not more a ground for refusal, but only an infringement of fundamental rights. And you have absolutely right. In the fundamental rights is quoted only the right of defense, and also in the opinion of the European Court of Human Rights. No. In the opinion of the European Court, it is fundamental to guarantee the right of defense and also the contradictory. No, in Italian system of law, in the opinion of Balsam, everything is okay. Also the contradictory. In the opinion of some lawyers, the contradictory in the proceeding in order to apply the preventive confiscation is not a real contradictory, for example. Okay, but we have to analyze also in the future. In any case, after this first meeting, we will have another important meeting in presence in Catania, in particular to analyze which are, in our opinion, the model of confiscation in our member states, and which are the model of confiscation in the proceeding in criminal matter that can be included in the scope of the regulation. So it is a very important moment, this second workshop of our research, also in order to know better our system of law. Now, Domenico Witold, please.
Good evening.
For Poland, we told Jakimko.
It's
from
very,
Poland.
take it away. Witold
Yes.
Jakimko. Witold Jakimko. Nice
Jakimko. Sorry, I have
nice to see you. In Spain, they call me Hakimko, which I like very much, honestly. But let me make some references to all our honorable lecturers. First of all, I wanted to thank them all for this very interesting presentation. Let me make a first reference to Mr. Spezia, what he said. In fact, the question of evidence level is not that important from the perspective of our goals. This is mutual cooperation is based, as we know, as certain recognized, mutually recognized standards. So there is an element of trust. We rather there are some other points that we should elaborate more, and making a reference to Mr. Albuquerque presentation, I would say he pointed perfectly one issue. The issue is that we are in European law, we are step by step going far and far from this classical penal concept and classical penal guarantees, safeguards that, can you believe, 30 years ago or 40 years ago, could any one of us even imagine a proceedings without a defendant, and that can cause any confiscation of seizure or proceedings after the acquittal? So in a way, we are going far and far from the classical penal concept of criminal law, and our goal within this project, I believe, is to determine how far we as the executing state, how far we go, how far we can go within this recognizing procedure. What can we allow within this recognizing procedure? And from the other side, we have to think what this requesting state, how can they go, and what they can really ask from their point of view. And well, the other goal is also to present this non-typical solution that exists in other countries, in order not to be that surprised when we have in hand a case file and we have to make a decision on that case. We all know this is not to be blamed. The European law is not to be blamed. Simply, the social relations are evolving, and the same happens with the law and the legal regulation. We have to chase perpetrators, offenders, because their way of committing crimes is more and more sophisticated. So we have to make some concession on the field of safeguards and guarantees. And we have to have this concession well thought and logical, and that can cause less harm possible to the defendant from the perspective of the safeguards. And the other issue I wanted to raise, it is about the presentation of Mr. Spezia. I would say, not only as a judge, but from my experience, if we have a contradictory, at least, let's suppose that this is always a contradictory proceedings. In contradictory proceedings, first, we don't need that much training for judges. I think that maybe for the first moment you will think, what is the idea? But in fact, this is the difference between criminal and civil proceedings. A judge is not creating a file, a court file. they have a professional at one side, prosecutor, and the other side is a lawyer. And simply they provide guidelines, and the judge can learn about any possible documents, can postpone the session in order to make a proper decision. Why I'm saying that? Because, you know, we can train those judges, but for example, what was postulated by Mr. Spezia is it cannot come true. For example, the court, specialized court that is dealing only with this type of cases of mutual recognition of seizure and confiscation. Why? For example, and I believe, and not only in Polish constitution, but also in some other state constitution, there is what is forbidden is a special court, dedicated special court to a particular thing. Except of military court during the war, there is special courts are forbidden by the constitution. And why it is so? You can easily imagine that it is also the question of proper case allocation. Can you believe that there are, for example, 10 specialized judges in a country like 40 million like Poland? And they are constantly doing the cases many times of the same defendant, constantly these 10 judges only. So, you know, this is a right to a fair trial also that can be harmed by this solution. But except beyond everything, it is not allowed by the constitution. So we have to find, to sum up, we have to find a kind of border stone in each and every system of the member states, and well explain them and maybe elaborate them more within this project in order to clarify and to leave a kind of artifact after our work that can lead a kind of guidance. I remember, because I took part also in elaborating in 2004 manual for judges on trafficking in human beings. So it happened that it was a kind of big manual with the examples and so on that was really useful and translated in some languages. It was in cooperation with International Center for Migration Policy Development in Vienna. So something similar that can be always in the courtroom or in the prosecutor office, that can reach and find the guidance. But the most guidance, you know, is needed individual, case by case, provided by the parties, because, as you know, all the cases are different. So, and once again, I wanted to thank you particularly also for the presentation of Mr. Balsamo, that maybe he doesn't remember me, but I learned about him when he worked in Kosovo. I also spent there a few years adjudicating. So thank you also to the Madam Chair for inviting such interesting lecturer and herself for the very nice and interesting presentation. Thank you to all of you. Thank you.
Thank you so much. Really, thank you so much. Okay, now I suppose that it is enough for today. I don't know if Amalia as Dr. Ressausina has to give some information for the future with our transcribe. Okay, transcribe would you like to say something? No, it's okay. Okay.
No. Thank you,
No?
Professor.
Thank you. Thank you, Professor Savona, for the participation. Matteo and Saso also. Amalia, have asked you to give some information for.
We will write to all of you about the second workshop.
Okay. So. Thank you so much. One of the aim or one of the commitment of our project is also to give, to try to elaborate guidelines for the future, for the interpretation of the regulation. So we will try to gather the fruits of this so intense workshop in order to try to draw some lines for the interpretation of the regulation and also some guidelines for the future. To Filippo Spezia, I would like also to say that we are at your disposal, the disposal of Eurojust, in order to collaborate as University of Catania, but also I suppose Transcrime, in order to elaborate the data of this first case, so to in some way, to give a support, an academic support for the monitoring of the Eurojust case in the first application of the regulation. Thank you so much to everybody, and we will meet in presence in the next meeting in Catania. Please, yes.
I am asking to Mr. Spezia if I can write to him an email requesting for the data for the benefits of the projects. Mr. Spezia, is it possible? Can we write an email to you?
Professor Savona, feel free to send an email. We can have of course, a dialogue would be a pleasure for me. With the caveat that I have already illustrated to you that some of the cases are still pending.
Okay.
In order to be to update you in real time, this is just the exercise we are conducting now with one of the main actors of the analyst project here, Susanna Fonte, which reached my office, and I would like also to give the opportunity to Anna Malgeri to involve Susanna in this project if she would like to. We are just talking about cases involving asset recovery in 2022 for the Italian desk, and we figure out that how many cases we have registered.
Okay.
43. So all these 43 cases, the new cases, the majority of them are still pending. So we need to check case by case if there is possibility to exchange some data, with the exception, of course, of personal data, and then to get consensus of the competent national authority. But anyway, let's proceed this way. When you wish, we can exchange email. It would be a pleasure for me, and then we see how we can cooperate. Okay.
Okay, good. Thanks a lot.
Thank you.
Thank you.
Bye.
Okay. Thank you so much. Bye.
Thank you so much.
Bye. If I may, if Susanna Fonte is on board, we can be we can be sure that the feedback from Eurojust is going to be exceptionally good. Thank you so much, Susanna.
Goodbye. Thank you.
Thank you so much.
Bye-bye.
Have a nice evening.
Bye.
Bye.
Bye. Thank you.
Bye-bye.
Bye-bye.
Good day, everybody.
Okay.
Bye. Thank you so much.